Investigation,
Beg pardon?
stage of investigation.
Actually, the entire FIR based on suspicion and imagination.
Oh, the FIRs are always imagination and suspicion, and it will be investigated, and the police will find whether the imaginations are correct or suspicions are correct.
My lord, the informant is a responsible officer of the government who has stated he suspected that he could know.
See, charges, see, the FIR is under 307 and all other sections. Investigation is still on. How can I interfere at this stage? Take down. The petitioner has filed this petition.
May I pray, my lord?
I will reserve your right. You can approach at right time, but not at this.
May I pray one thing, my lord? There are two accused persons in this FIR. No. In respect of one accused person, this honorable court has been pleased to pass one order that he is the owner of the vehicle and he is a poor workman under the
Show me that.
drive.
What does it say? Your court says that you surrender. Court says you surrender. I'm giving you a better order. I'm giving you a better order saying that you reserve your right to come at the appropriate stage. I will not say whether you surrender or not. It is your call. You can surrender. You don't surrender. It is your call. Right on. The petitioner has filed this petition under section 482 CRPC, seeking quashing of FIR number so and so, particular so and so, so and so. Mr. Ragada, appearing for the state, submits that the case is at investigation stage, and charge sheet has not yet been filed.
The petitioner also not absconded till it.
Charge sheet has not been filed. And he also submits that the petitioner is not cooperating with the investigation and avoiding the investigation. Next, I'm of the view that the present petition is premature, and since the investigation is on, I'm afraid whether the jurisdiction, inherent jurisdiction of this court is available to the petitioner at this stage. Hence, the petition is dismissed, reserving the liberty to the petitioner to approach the court at appropriate stage in the appropriate proceeding. Yes, next two.
May I submit one thing, my lord?
Yes.
In this case, this honorable court has been pleased to grant some privilege to this the owner.
This court says only that you surrender and take the bail. That's what it says. I'm giving you that liberty. You go and do it, whatever you want.
No way. To the lordship, have a glance to para 8. What's the bottom?
This is not a permissible under law. You are wrong in the wrong court. How can in a 482 petition I can say that you release on bail if you surrender? You are not able to make out a case of 438. You want a regular bail in a 482 petition. How can I say that once you surrender, you shall be released on bail in a 482 proceeding?
No, that is the order. I just
so I can't do it. I can't do it. Perhaps you are in a wrong court. Next, number 2. 6, okay. 6 to be taken up. Why? Okay. Item 6.
May Lordship. Last occasion, Lordship directed to appear the personal appearance of the both.
Yes. Are they here? What are the offenses?
Lordship, initially FIR was registered offense under section
307 also were there.
later on charge sheet has been filed.
308.
308.
Also, it's the same. We'll do it. Petitioner has invoked the jurisdiction of this court under section 482 CRPC, seeking quashing of the FIR, FIR number so and so under so and so, and consequential proceeding arising therefrom. The party next paragraph. The notice was issued earlier? No.
No, my lord.
The counsel for the petitioner submits that they have settled the dispute with the opposite parties. Oh, have you implemented opposite party? Opposite party number 2.
Two.
Full stop. Opposite party number 2. Both the parties are present in the court along with their respective counsels, and they filed their self-attested copies of Aadhaar card to establish their identity. The parties have also filed the affidavit before this court inter alia stating that they have settled their dispute among them. The Mr. Ragada appears for the state and submits that although the FIR was initially registered under 307 IPC along with the other offences, but after investigation, charge sheet is filed and 307 has been dropped. Taking into account all these facts and circumstances, the FIR number so and so and the consequential proceeding arising therefrom are set aside.
Obliged.
Sign kar do. That's it. Next.
Item 2.
Yes.
Item 2, my lord, may I pray for 2 weeks time, my lord?
2 weeks.
Item
Urgent. 2 weeks. No, you will give it.
Item 3, my lord, may I pray for one adjournment? I need
Urgent.
some instruction.
I have objection, my lord.
Objection.
Yes,
Why?
my lord.
Why
My lord,
is
this is a 138 NAC, my lord,
Oh.
challenging the order of
You-
NBW, my
You
lord.
got a stay?
Yes, my lord. He has, he
Why?
obtained a stay order by enjoying the stay order.
No,
Yes, my lord.
I need not, I don't want to enjoy the stay order. I need to have some
No,
instruction.
you don't want, but you are enjoying.
No, my lord.
That's what it
Just
is.
recently, since your lordship, in presence of my senior brother,
See, you have taken the interim order.
my lord, I
on-
need only one adjournment, my lord, because I need some instruction from the petitioner, but I could not able to contact because he is working under the medicine company. Perhaps he is out of state.
What is the instruction you want?
I need some instruction.
What?
Regarding the brief,
Regarding the brief or something else?
I instructed him earlier. I instructed him to settle the matter out of court.
Now, if regarding the matter, if you have sought instruction, let us see whether instruction is required or not.
I
If
need
it is
some,
otherwise some instruction, then I'll adjourn it.
I need some instruction regarding this settlement of the matter.
Then let us see whether it is really required or not. Let us see what is the complaint.
Petitioner was under 205, my lord. Because he could not able to, because of communication gap with the conducting counsel, he could not able to before the London court below. That's why NBW has issued.
No, my lord. Sufficient. 205 allowed. He filed undertaking. After file undertaking, he consecutively absent before the trial.
I record his statement and undertaking that he will appear before.
Yes, my lord.
court.
Your lordship,
And
all-
dispose it up. He's going to appear.
I need only one adjournment, man. At
I'm
least
giving you relief. I will stay the.
Since last 10 days, I could not able to contact the petitioner. That's why my humble.
That's right, but if you, I'm giving you relief, what is the big problem with you? I'm setting aside the NBW order and ask you to go and surrender and take, because it's a bailable offense, you will get it. What is the big
Obliged,
problem?
man. Obliged.
I'll allow it.
Obliged.
I will allow it.
Yes, Lord.
Why to stall it?
Yes, Lord. Yes, Lord.
Obliged, man.
Lordship, a
Huh.
target may be fixed in, so that
That I am not sure whether target. Where is the order? Only you are agreed by this NBW order.
yes.
My lord.
Isn't it? I'll set aside that order.
Obliged.
I'll set aside that order and you tell me when you will appear.
Because I could not. That's why I am seeking. I am praying before your lordship next week any day, my lord.
Next date appearing, whenever the trial court fix, you go and appear.
My lord. Because of I could not able to contact.
It's all right, you tell now. Which is the order, impugn order, NBW?
Your lordship order dated,
Yes, that is 16/3/2023, isn't it?
order
Six,
dated
3, 4,
3/4/23.
Next order. Either
3, 4.
bidole, first order bidole, next order.
The petitioner has filed, the present petition is arising out of a complaint under section 138 NI Act. The petitioner is the accused in this case, whereas the opposite party, number 2, is the complainant. The grievance of the petitioner is that on 3/4/2023, this court below has issued the NBW against his client. Therefore, he has filed the present petition seeking quashment of the order dated 3/4/2023, whereby the trial court has issued non-bailable warrant against his clients, against his client. Against the next paragraph. I heard the counsel for the parties and counsel for the petitioner submits that he would be appearing in the court on the next date of hearing when the trial court when the matter is scheduled for hearing in the trial court on the basis of his statement. I am of the view that the NBW issued by the trial court on 3/4/2023 should be quashed, and accordingly the next paragraph. Accordingly, the present petition is allowed. NBW order dated 3/4/2023 issue passed by JMFC LR Cuttack in 1 CC case number 942 of 2018 is quashed, and the petitioner is directed to appear before the trial court.
By the next date positively.
Whenever the matter is fixed.
I don't have any information regarding when matter is fixed.
Then you tell me the date.
May I appear on or before 16th February?
On or before, appear before the trial court on or before
16th February.
Go and face it, unnecessary why to keep it. Okay.
Our name may be reflected in the orders.
Hmm?
Our name may be
Yes,
reflected.
yes, yes. Heard so and so. Yes,
Item 4.
yes.
This matter, that's it. I have challenged the second charge sheet filed by the investigating officers.
You are implicated in the second charge sheet.
First charge sheet, I am the accused. I am the director of the company. And now during.
You are not agreed by the first preliminary charge sheet.
I was facing trial. The first IO was examined by me. Second, there are the 4 DSPs in
Was
the,
173.8 was open.
173.8 was open, but on that point I would like to argue that in that aspect, let's always we say investigation is open. Now, when
Further investigation. is open.
further investigation is open here, there are documents on 102, 300, 400 pages. That's it. The subsequent same footing, there was no other document by the 4th DSP. He filed it saying that cognizance shall be taken on the same section. Let's say I would like to take my note that further charge sheet. My only point, let's say, is
Where is
I'm not
where is the preliminary charge sheet? You have not filed preliminary.
let's say I am not well ready. That's why I'll just touch it because let's say we fix it on Wednesday. I could finish on this serial. I could finish it.
But you are challenging the further charge sheet.
Let's see.
Apparently on the ground that the further charge sheet is nothing but it is a repetition of the earlier charge.
Let's see.
That's what you want to say.
Therefore, my lord,
If that is the case, if you don't place the first charge sheet, how will I know?
that's what I would like to place it.
And even if I'll take your argument to be correct, and what is the prejudice? 173.8 was open. If they repeated it, how does it make difference to you?
Difference because let's see, they come with other documents that
They can very well come.
That's what I would I'm like to take my lord all the documents so that it will be convenient for my lord to
You want an adjournment.
adjournment for
Adjourn- But you place on record the first preliminary charge sheet.
Let's see.
Let us
But
see
these are the first preliminary charge sheet is all over this.
what to do.
ମାନେ ଚାରି ଟ୍ରଙ୍କ ଅଛି, ଚାରି ଟ୍ରଙ୍କରୁ ମୁଁ ଏତିକି କଲେକ୍ଟ କରିଛି।
जो केस रे बहुत document ଥାଏ ସେ acquittal हमारा easy. You better that I'll expedite the trial, go and face it.
No, Lordship, I am on the footing, I will get better order.
Prima facie, I am not with you. Still, if you want to file, it's all right. You file, it,
Let's-
no problem.
Lordship, on Wednesday, next Wednesday,
I'll just adjust it and give.
Lordship.
I'll just adjourn it and adjust it and give. Because it will take little time, it appears to me. We'll adjust it. Don't worry.
Lordship. Lordship, till then, interim order continue.
Already there is an interim order. That is why you are bringing all this volume to show me to make it extended.
This is the time. I'm not saying intention side.
Let,
Intention mata 2-3 घंटा लगे.
let trial is continuing and the interim order is to file an adjournment applications. Your lordship may
You
fix up,
may-
Lordship,
Now, what I'll do is, let the trial continue.
yes,
No,
No
no.
final order will be pronounced.
no,
Yes.
Lordship, I have to cross examine.
करिए,
Both charge sheet.
I'm not staying cross exam. You
No, no,
cross
Lordship, once I have cross examined, I am in the process. Because the competency of that second charge sheet, I am challenging because of Article 20 Lordship come into this.
20 will not come in your aid
That's
because
process of law.
173(8) is open, they can file it. And if you say that it is a repetition of the earlier one, take the advantage of that in trial.
For that purpose, I would like to take my lord the first charge sheet, then compare with the second charge sheet.
Chalo, anyway, give it. Let us see.
Today that OPID court has fixed the date. Let's see.
You seek adjournment. There is no order as such. I have seen it. There is
Last order, let's see, first order was stay of the proceedings. Second order was, let's see, Honorable Court was pleased to grant me liberty for since matter is pending, you file application.
You do that same thing. I'm not saying anything. Simply adjourn, that order will operate.
Let
order.
me kindly say.
Okay. That order will operate.
I
Next.
think my
Fine.
lordship may fix up short date so that it can be disposed.
Date, he will give adjust the date and
Well,
so that the next listing it will not go waste. We hear it and finish it. Yes.
May I please, Lordship?
Yes.
My lord, this is arising out of a matrimonial dispute, my lord.
Hmm.
The present petitioners are the parents in laws of opposite party number 3, my lord. The
Opposite party number
3.
3. Okay.
Opposite party number 3 is the informant, my lord, in this case. The affair was lost in the year 2022, describing the incident of 2015, my lord. After the matrimonial dispute has been started, my lord, may come to page number 90 for a moment, my lord.
90.
190, my lord.
Yes. 90. Okay. Now,
This is a transfer petition which has been filed by the present opposite party number 3 before this honorable court. In paragraph number 3 of this transfer petition, it has been categorically stated that the petitioner is the legally married wife and their marriage was solemnized on 7/7/2017. That the petitioners one male child born on 2018. So the present opposite party number 3 has got married to the son of the present petitioners in the year 2017.
and there was a child.
There was a child in the year 2018 out of the wedlock.
Okay.
The matrimonial dispute has been started. I have enclosed the annexure 2, which starts from page number 13, my lord, 13.
Yes.
This matrimonial dispute has been filed by the son of the present petitioners, impleading the opposite party number 3 before the learning judge family court Fulbani, White CP number so and so,
Seeking what?
seeking divorce under section 13, my lord.
Okay.
After filing of this petition under section 13, due to maintenance ground, this present affair has been lost. The present affair has been lost. That is under annexure 5 series, my lord. That is 20 page starts from 26.
What is 376(2)?
That is what I am coming to, my lord. The allegation starts from page number 28.
Mhm.
As per the informant, that is opposite party number 3,
Hmm.
she is stating that when she was 16 years old, that is in the year 2015, and the affair was lost in the year 2022, and impleading the present accused persons, that is the petitioners and the son of the petitioner, in not only in the 376 2N but also in the various POCSO offenses.
2016.
2015 matter is relating to 2015.
2000.
In the year 2017 they got married. In the year 2000,
22 files. What is this, Mr. Ragada? This is absolutely, see, what happens is this lady marries this boy. And
17 married.
There is a child. Thereafter, what happens? This boy files a
Matrimonial
divorce petition. The moment divorce petition is filed in 2022, she files an FIR saying that when I was 16, way back, I was raped and all. Sir, therefore, POCSO is invoked. What is this? Prima facie, this is a, this is a motivated case and making all of them accused. It is a matrimonial dispute.
He has given the all the copy, my lord.
Ah.
But in fact, the case has not been called for, my lord. One time chance may given, my lord, call for the inter.
But it is absolutely.
My lord, it will be better, my lord, one day dispose. For that, my given.
What is the stage of investigation?
The investigation has been closed. Cognizance. I am challenging the cognizance order, my lord.
Cognizance.
Cognizance
One
order.
date may given.
I'll stay the property.
Yes,
It is absolutely a frivolous case.
One date may given.
Look, the petitioner has filed the present petition seeking quashing up for the criminal prosecution initiated against him. Where is the cognizance order? Date, which page?
4/7/2023. That is at page number 157, my lord.
157.
Annexure 9, my lord.
9.
My lord.
And the cognizance order dated 4/7/2023. 23. Good sir. The Learned Court below has taken cognizance of the offences under section so against the petitioner. Next one. Mr. So appears for the petitioner and submits that the transfer petition filed by earlier the informant had filed a transfer petition. Which page you have shown it? That
90, page number 90.
90.
But the
Okay, 19.
It starts from page number 87. Sorry, my lord. 85, my lord.
85.
Annexure 6.
Earlier, the opposite party, you have implemented opposite party Upasana?
Yes, my lord. Opposite party number 3.
Number 3. Earlier, opposite party number 3 had filed a transfer petition being TRPC number 18 of 2023 before this court. Against the petitioner.
No, son of the petitioner.
Son of the petitioner. Inter alia and para 3, stating that she has married the son of the petitioner on 7/7/2017, and a male child was born in 2018 from this wedlock. It appears from the record that the petitioner, there was a matrimonial discord between the opposite party number 3 and her husband, namely the son of the petitioner, and who has filed a divorce petition. Which is the page?
Page number 13. It starts from page number 13, my lord. 13.
Divorce petition being CP number 37 of 2023.
18. 2018.
2018. The next paragraph. After receiving the copy of the divorce petition, the petitioner, the opposite party number 3, has now lodged this FIR in subject, making allegation that 5 years back, 5 years was it?
My lord, 6 years.
6 years back, when she was a minor, she was raped by the son of the petitioner, who is now her husband.
Yes.
On the basis of which the present FIR is lost. Next paragraph. Issue notice to the opposite parties, Mr. Raghuda waives notice for the state.
Or 1 and 2, my lord.
Returnable within 1 week, written with
Or 1 and 2, my lord, to the inspector in charge and
1 and 2 कर दो. तब लिखो, in the meantime, the proceeding pending before the court of
My lord.
also,
One
court
Pokso.
of
My lord, 157.
Huh?
Additional district
Special
and
judge POXO.
Additional district and
district
session judge.
Session judge.
POXO.
POXO.
Fulbani.
Fulbani in CT case number 550 of 2022 is stayed till further orders.
OPIT 3 may be directed notice to the OPIT 3.
Huh?
Notice issued to the OPIT 3.
All.
My lord, one thing, my lord, and page 2, my lord. Certificate given by my learned friend, my lord. They mentioned that available which has been disposed of, protected, and though the CLMC 1056 of 2023, which has been disposed of, dated 75/23,
My lord,
has been dismissed on default. Therefore, interim application
if challenging the affair, I have filed another
that will be
482.
pending.
Challenging affair, but no 482 petition has been filed.
What happened that case, my lord?
I have disclosed.
FIR request, my lord.
No,
No, you had filed another petition
challenging
for
the affair.
passing
That
affair.
was
What happened to that?
that was dismissed for default, and I have filed the restoration
Restoration,
petition.
my lord.
That
Then
is
how
also
are you repeating this?
Repeating this.
no, my lord. I have filed this petition challenging the cognizance order here. Cognizance
What
order.
is this?
My lord, initially I have challenged the affair. That was
Also,
that was tagged before this honorable court in this.
Restoration
They have tagged that matter. in your-
It is tagged, my lord. It is already been tagged.
Why are you spoiling the case of your clients by doing all this mischief? You have a good case, you argue on merits, you will be coerced
My lord.
unnecessarily.
Deeply obliged.
Yes. Hmm?
First
Little.
Article.
Already.
Notice.
Make 8th, 9th, some. 8th,
12th.
12th, huh?
12th February.
Deeply obliged.
Yes.
Item 7.
सब आइटम जो आइटम 5 रो सब आइटम टा डिफरेंट मैटर गोटे भूल रे टैग हे जी
Retag करके और डेट दियो. चलो, next.
Item 7.
May I please, Your Lordship? There are two items. As per your Lordship's direction, my lord, I am filing the joint affidavit. With
Settle.
the, yes,
What is the offense?
my lord, 436/511.
36 file.
Yes, they tried to set fire in front of the office, in front of the company office.
Who is your opposite party number 2?
My lord, I am for the OP number 2. Matter has been settled, my lord.
Yes, Mr. Raghuda.
Last time, we asked them to present in the court, my lord.
Are they present?
All, yes,
The petitioner has filed this petition seeking passing of FIR so and so under section so and so. Notice was issued to opposite party.
yes.
Uh,
Before issuing notice, my lord, he was appeared, so much appeared.
Or that in
The matter was taken up by this court on 11/1/2024, 24, and the following order was passed. Pursuant to the aforementioned order, the parties have now present before this court, and they filed a joint affidavit inter alia stating that they have settled their dispute. They have settled the dispute to maintain on the intervention of the village gentries and to buy peace and tranquility in the area. They don't want to pursue this case further. The parties are present before this court today. They filed their Aadhaar card, self-attested copy of our Aadhaar card, which are to establish their identity. They are represented by their respective council. They identify the petitioners, the petitioner in opposite party number 2. Next program. Mr. Raghuda submits that. Mr. Raghuda submits that the parties have, since the parties have settled the dispute out of court, and there is no legal impediment in passing this FIR. Next program. having taken into consideration all the aforementioned facts and circumstances, the FIR number so and the consequential proceeding arising therefrom are satisfied. Next.
Lord, the second item, another item is there, 5-1,
Same-
5
same
sub,
parties,
same
same
parties.
parties you do. it.
Informational.
My lord, only my prayer is there are 3 accused persons in this case. I have filed for 1. With amended cause title, my lord, and Wakalatnama, I am filing this.
But take it on record, pass the same order, no problem.
My lord, this is the affidavit.
Take it on record and do it carefully.
Amended cause title is there.
Yes, it should.
Oblige.
Next.
Those. Oblige.
Offenses are same or different?
No.
All are, informants are different and petitioners are same.
Offense is same, everything.
Yeah.
No.
Offense is 387, 457.
ठीक.
Oblige.
Okay.
Item 9.
9. Yes.
In item number 9, Senior Advocate Luthra sir is appearing.
Where is
Siddharth Luthra, Senior Advocate.
Luthra? Yes.
So-
I'll pass it over. See if he's there. You call him if you can join.
Well, great.
Item 10.
Yes.
May I please, Judge? NBW situation due to no steps have been taken on behalf of the,
You are on bail.
yes, madam.
Offense?
Offense 363, 365,
Okay.
And-
When you got the bail?
well, 28/11/2013.
Or TC?
Yes,
11, huh?
11/2013. I have annexed that
Okay.
bail
yeah.
order,
Where is the,
page
you
12.
are facing the trial now?
Yes,
Where is that? Or TC, na?
yes,
Is it?
page 12, I am
Oh,
in.
2019, the NBW was issued and
Yes.
now you are coming. What is this? How much will you pay?
Baba loko to kuade pade.
Huh?
Baba loko allegation.
बाबा लोगों को काम करियो एमनी बाबा लोगों को देखो the petitioner has filed this petition assailing the order dated 28/2/2029 29 whereby the trial court then special judge court of special Jajpur
Yes,
Jajpur has been pleased to issue NBW against him for his non-appearance in the court. Then counsel for the petitioner submits that he is on bail from 28/11/2013. 2013. However, due to communication gap, he could not appear on 28/2/2029, leading to the issuance of the LBW. He undertakes to appear before the court as and when the court requires his presence. Next, having taken into consideration the facts of the present case, the order dated 28/2/2019 passed by the special judge Jajpur is set aside. Subject to the petitioner paying a cost of rupees 1,000 to the welfare fund of the High Court.
Orissa High Court Bar Association.
Orissa High Court Bar Association. 1,000.
yes, ma'am.
Okay, next.
Oblige, ma'am.
Item 11.
Yes.
My lord, may I request for item number 9?
Huh?
Item number 9.
Item?
Item 9, that Passover item.
Yes.
Item 9.
Yes.
If I may, Lord, if I may, Lord.
Yes.
This matter relates to the breach of the regulations. What is happening is, and I'm dealing, Lord, if Lord just considers for the, not this 4334 Gauguin Foundation.
With item 33 and other.
Item 33, but they're all related, all connected matters. The whole issue in these matters is that there are,
How many connected matters are there?
In item number 9, there is one matter, my lord.
Yeah.
And in item number 33, there is 17 item,
17.
my lord.
Okay. Yes. Issues are same.
the issue
No, my
is,
lord.
but short issue in all these matters is this is a matter relating to interim custody of cattle and vehicles for offences under the Prevention of Cruelty to Animals And there are specific rules, which are the animal rules of 2017. Our case is, in all these matters, the learned magistrate proceed with these matters once the animals are not located. They are direction by the rules, but going by 457 CRPC. And that is with respect to a breach of the law. And if I may just point out, Lord, one or two things, but therefore we are really seeking guidelines in that sense. If my Lord is just kind enough, is the lead file? Yes. But if my Lord is just kind enough to see for a
Luthra, can you
moment.
increase a little volume?
Yes, Lord.
Yes.
Lord, I'm sorry, my apologies, Lord. Can your Lordship hear me now?
Yeah.
Now, Lord, to put it simply, there is an FIR which is registered, Lord, this relates to this item 33.
Item 9.
Item 9, sorry, item 9, I'm sorry, item 9. FIR is registered on 30th of August 2023 at Khera PS under 11A and 11B of the PC Act. Now, Lord,
Yes.
cattle are being taken on foot, which is against the rules. Man claims to be owner, he has no purchase receipts. Police hand over the cattle to the Gaushala for care and maintenance. Why does Mama? Because they're weak. Lord, thereafter, the second respondent moves an application saying that these animals be released to the second respondent. And that application is moved before the magistrate, which is A4 at page 29. There are 180 cattle in this matter.
132 was completely injured.
132 were in not injured condition, and that is very clear. Lord, I'll show that to your Lordship. Thereafter, Lord, what happens is he doesn't disclose why he's taking the cattle. Ownership is not there. In any case, Lord, he moves his application on 1st September 2023, which is A4. We move an intervention application pointing out to the learned magistrate that the rules will apply. Please consider the rules. The learned magistrate, however, calls for a report from the I. This report is clear that 132 of the 180 cattle have signs of lameness, sprain, rope ball condition, lacerated injuries, etc. The GMC rejects it and says, I'm not entertaining it, and directly follows the mandatory petition, keeps it pending. Now, I'm not against this. We are handy. Just see that for a moment. That is the order, not which I want your Lordship to see for a moment.
That is the order dated 16/9/2023.
But 1st September
Come
1st,
to-
please see the
then
1st
come
September
to
order.
the annexure 2 then. Let us see what is the order. Then this is what you have impugned.
Number of order. Yes, Lord. First order, Lord, my Lord will see. Lord, just a minute, Lord. Just a minute, sir. First order, Lord may see for a moment, which is I want your Lordship, Lord, will challenge impugn 16/9, but I want you to see 1st September for a moment. Just a minute. This is important because it shows to your Lordship that release is sought in terms of 457 CRPs. Now, please come to 16. Now, in 16/9, Lord order, my Lord may see, it's an order which begins at page 21, and the court gives a direction at page 23. We raise this objection in the third paragraph from the bottom.
You are not
saying
able to
that you
hear
can't-
my.
See, the problem is I can hear, somehow I can manage to hear you, but the prosecutor here is not able to hear you. That's their grievance.
May I just say this, if my 2 o'clock, Lord, I'll join from another device. By the, Lord, I'll join from another connection, Lord.
Okay, let us
Or
make it 2
12:30, Lord,
o'clock.
whenever it's 2
Yes,
o'clock, Lord.
that's fine. That's fine.
I'm deeply.
The prosecutor can't hear. So you-
But I'll make sure, Lord, I'll do my best, but 2 o'clock.
Okay, let us make it at 2 o'clock.
Grateful, Lord, deeply obliged.
You join in another device so that we can hear.
Yes, Lord, I'll do that. I'll do that, man. I'm grateful.
That is it. Yes. Next. Item 11. Yes.
May I please, your lordship? My lord, I'm challenging it.
When have you got the bail? What is the offense?
Offense under section 506 along with other offenses, my lord.
Anyway, you tell me when you got the bail.
This is your old case, my lord. I have no information regarding bail, but petitioners were on bail. Your lordship,
Right
kindly
now,
see page
the
8.
petitioner has challenged this, petitioner has filed the present petition challenging the order dated 22/7/2023, whereby the trial court had issued NBW against the petitioner, NBW against the petitioner. Petitioner is facing trial for trial in ST case number and GR case number. GR case number 48 of 2011 under section so and so, you take it from page 7 before the court of JMFC Ranpur, by the JMC Ranpur. Then counsel for the petitioner states that his client has been enlarged on bail in this case. However, on 22/7/2023, he could not appear in the court. Hence, he seeks interference of this court. He also undertakes that his client will be appearing on the next date of hearing when the matter is fixed before the trial court. Having taken into consideration the facts and circumstances of the case, the order dated 22/7/2023 is set aside. What is your client doing?
Sorry, my lord.
What is your client? How much you will pay
Cla-
to the bar?
Class are of villagers, my lord. Your lordship,
How much you tell?
your lordship, direct.
How much you pay? How many of you are there?
6 ଜଣ ଅଛନ୍ତି ଆଜ୍ଞା।
5 ଟଙ୍କା ଲେଖା ଦିଅନ୍ତୁ।
ଏବେ
Huh?
they will pay, my lord.
They should be 5 6. Set aside, subject to the each petitioner paying 500 rupees as a cost to be deposited with welfare fund of High Court.
Orissa High Court.
Orissa High Court.
Item 12.
Yes.
My lord, item 12 may I pray on behalf of Mr. Sahu. This is also challenging the order of NBW. Same, my lord. But I have committed one mistake in constantly. That is in place of 2022, noted 2023.
It's all right.
May-
No problem. No problem. 22 at 12/12/22, na?
My lord.
12/12/22, yes.
My lord.
Offense?
Hence, my lord, all offences are 506 along with your
Oh, right on. On bail?
we are on bail, my lord.
Same. How many of you are there?
My lord, 5 persons.
Same 500 rupees?
Obliged, my
Huh?
lord. Obliged.
Same also, 500 rupees.
It's a number,
What?
right?
Huh?
It has bar number item.
500 rupees you pay.
Obliged, my lord.
After all, you are paying to the bar only.
Because my brother was here, he was the secretary of the Bar Association, Mr. Ragada. And also
happy.
he was the voracious criminal practitioner of our association.
Yes.
Obliged.
Item 13.
May I please? Now, under section 138 NI Act, my lord, NBW was issued on dated 28/10/2022, my lord. It is for
Check
to
the amount.
appear, check
amount.
bounce, check
Amount.
amount, my lord. 2 lakhs, my lord.
2 lakhs.
20% deposit.
That
Whatever
will
it-
decide why should
this-
I say anything. This is a
Appear on or before February 16, my lord. Savita.
where is the NBW order? Order is dated 28/10/2000. 28/10.
This is case number.
Where is that? 28/10.
Page 7, Annex
Page
1.
7, Annexure 1.
7 ना? 28/10 कहाँ है? Order ही नहीं. हाँ, 28/10. ठीक है. The petitioner has challenged the order dated 28/10/2022, whereby the JMFC court part has issued the NBW against the petitioner. But this case is arising out of a complaint under section 138 NI Act. The NI Act initiated by opposite party number 2.
2.
For alleged offense of dishonor of check of rupees 2 lakh.
2 lakhs.
2 lakh rupees. The counsel for the petitioner undertakes that his client would be counsel for the petitioner states that the client would be appearing in the appearing before the court on or before
16 February.
on 16 February. 16 February. Having taken into consideration the facts and circumstances case, the order dated 28/10/2022 passed by the JMFC Kotpad in ICC case number 2 of 2022 is set aside subject to payment of cost of rupees. How much? 500, huh? 1,000.
500
Oh.
out.
500 is insult to you.
Se hare ye korche chakri rohichi ke mane kamo korche industry.
No, you are such a senior lawyer, it is insult to you. So therefore I will make it 1,000. 1,000.
My lord judge.
You tell from
500.
500. Okay, 500. Next. Yes.
May I please? The petitioner was earlier on bail, my lord, and on 24/11/2023, the NBW was issued.
NBW.
Yes.
When you got bail?
My lord, he was released on bail under Annex 2 in BLAPL number 5252.
Tell me this.
The date was, my lord, 16/8/2021.
2000?
21.
Acha. NBW?
The NBW date is 24/11/2023.
Condition? Bail condition?
Bail
Not
condition is, my lord, that is
not complied, it seems.
my lord, the condition is that condition that he
Okay, I'll
Each date of posting appeal. Condition is there.
condition it.
Yes.
317 petition was filed, it was rejected and NBW was issued.
Why are you moving such application? If you got the bail with the condition that you will appear, you appear. You took bail on that condition and now moving application.
How she
The petitioner has filed these petitions seeking quashing of the order dated 24/11/2023 passed by the additional sessions judge cum special judge Koraput at Jaipur in TR case number 30 of 2021. The petitioner was enlarged on bail by this court on 16/8/2021 while allowing his application, bail application BLAPL number 5252 of 2021. While granting bail, the coordinate bench of this court has imposed a condition that he would be appearing in the date of hearing. Contrary to that, the petitioner moved an application under 317 CRPC, which was turned down, and NBW has been issued. NBW has been issued. The counsel for the petitioner submits that his client would be appearing before the court on or before 15th of February. 15th of February. On that condition, the order dated 24/11/2023 is set aside, subject to payment of cost of 1,000 rupees to the Bar Association, so on so on.
There, Lordship, my directment. Before the DLC, Jaipur.
No,
cost.
cost High Court. You give High Court. High Court welfare fund.
May I please, Lords?
Yes.
May I please, Lords? NBW has been issued me on 11/12/2023, my lord.
Yes, offense?
Offense 409, my lord.
Okay. You are on bail?
Yes, my lord.
Huh?
Yes, my lord.
When?
On 26/8/2021, my lord.
6/2021.
Yes, my lord. 26/8.
Okay. How much cost? 500.
500.
500 cost, same order.
Okay.
Okay.
16.
My lord, questioning of NBW, my lords. It was
What is
issued
the offense?
138 Act, my lords.
Granted bail on 26/6/2021. Okay? Be careful. Next.
138 Act, my lords.
The petitioner has filed this petition seeking quashing of order dated
11/12/2023,
whereby NBW has been issued against him. He is facing the opposite party number 2 has initiated a complaint case against him for the alleged offence under section 138 NI Act for having dishonored the Jacob. What?
1,70,000.
1,70,000.
70,000.
70,000. 1,70,000. The counsel for the petitioner submits that his client would be appearing before the court below
On
on or
31st,
before
31st January, my lords. The matter has been posted to that date.
his client will be appearing in the court on the next date appearing before the court below. That is on 31st of January 2023. 2023.
104, my lords.
The next, having taken into consideration the facts and circumstances of case and the order dated 11/12/2023 passed by the court of
GMC Nimapura.
Nimapura
My lords.
in ICC case number 166 of 2018 is set aside subject to payment of cost of 500. Bar association. Yes.
Item 17.
2006.
Can you excuse me for 5 minutes?
Yeah.
I'll just snap.
Yes, sir. We'll have a cup of tea together. We'll have it after 5 minutes.
I'm comforted. Complaint or 156.3?
It's 200.
156.3
complaint.
Okay.
And I'll demonstrate from the complaint itself that no offense whatsoever is alleged against many of the officers here.
Is there
So
any
that-
order on 156.3?
Yes, already investigation completed and charge sheet filed.
FIR was
Yes, yes.
registered and
Yes,
thereafter.
yes.
Yes.
I emailed invoked in the meanwhile 482 here. The court gave me the liberty that you go back, file a petition for discharge, make all the grounds, and the court would be obligated to consider each of your points, including.
Against that rejection of 227 application, you have come here.
Yes, that's right.
Okay.
And
239.
239.
506 master tribal.
here it is.
Sessions case, okay.
The
Here
master
it-
tribal.
Here, my lord, it is 239.
Yes, yes,
Before I tell you the facts, can we quickly have a look at 239 for a second?
okay. Yes. Yes.
When accused shall be discharged. You have seen that, 239?
Yes.
If upon considering the police report and the documents sent with it under 173 and making such examination, if any, of the accused as the magistrate thinks necessary, and after giving the prosecution and accused, so both of them would have to be given an opportunity of being heard. The magistrate considers that the charge against the accused to be groundless. This is important. He shall discharge the accused and record his reasons for so doing. It is this exercise of the power that was asked to be done while I invoked
The
482.
real test is if you, on the basis of this material, you put an accused to trial, it shouldn't go in futility.
Thank you.
That is the whole
That-
idea of
that's the
this
whole-
amendment.
whole philosophy.
Therefore, the expression groundless.
Groundless.
That's right.
So I will try to demonstrate that from the documents which are collected by the police and form part of the charge sheet, there is absolutely no ground as far as we are concerned, which means, alternatively speaking, they are groundless. And I'll show you from the impugned order,
We are concerned means you, six of you,
6 of us,
okay.
which are all officers of Marat. Kindly note one thing, Jindal power. Now the allegation apparently appears to be against the Jindal power.
How many accused totally?
6.
Only six?
6.
All of you.
All of them at the relevant point of time were working as the officers of the Jindal power. I'll show you from the complaint that the allegation apparently is made against Jindal power, not against the officers. Because whatever that is purported to have been done by these officers are apparently at the behest of a company called Jindal Power. Now the Jindal Power is obviously not made an accused here in this case. And I'll also demonstrate you from the records as to how many of the total problems which have been created during the investigation. Well, please, to begin with, please see the complaint at page 28, 30. And at 30, what he says, the complainant.
30.
30. निवेदन अभिप्राय है कि जे मु प्रताप धड़ सुवांशु अनुगुल ए 28th of October 2015 संध्या 5:20 रे आम परिवार मौजा रे थिबा घर खाता नंबर सुवांशु मार्क दिस खाता वाला
Yes.
and then he is making Suresh Sharma, Ashish Pandey, Ashish Mohanty, Sujit Pradhan, Sushant Mishra, Anil Panigrahi, Padan Naik, Sushant Mishra, Anil Panigrahi. Asi mo Maku, Sali Budi, Salah,
Slang language.
Madhurchod, Halami,
All these expressions.
Yes, that's right. So therefore I'm ignoring for a good reason. Feki dele.
କହିଲେ ଘର ଭିତରେ ଆଉ
କିଏ
କିଏ
ଅଛନ୍ତି?
ଅଛନ୍ତି?
ମୋ ମା କହିଲା ମୋ ବୋହୁ ଅଛି ଘର ଭିତରେ
ନାଇଁ ନାଇଁ ତା ପୂର୍ବରୁ many things. ମୋର ଚୁଟି କୁ ଧରି ଭିଡି ଆଣି ବିଧା ଗୋଇଠା ମାରି ବାହାରକୁ ଫିଙ୍କି ଦେଲେ।
Yes.
କହିଲେ ଘର ଭିତରେ ଆଉ କିଏ କିଏ ଅଛନ୍ତି? ମୋ ମା କହିଲା କି ମୋ ବୋହୁ ଅଛି ଘର ଭିତରକୁ ଯାଅ ନାହିଁ। କହିଲେ ତୋର ବୋହୁର ଇଜ୍ଜତ ନେଇଯିବୁ। ସେ ଆଉ ବାଟରେ ମୁହଁ ଦେଖାଇ ଚାଲି ପାରିବ ନାହିଁ। ମୋ ମା ଏହାକୁ ବିରୋଧ କରିବାରୁ ମୋ ମାର ହାତ
ଗୋଟକାଇ ଆମ ମୋବାଇଲ ଫୋନ ସବୁ ଛଡାଇ ନେଲେ. So here the omnibus allegation comes. ଗୋଟକାଇ ଆମ ମୋବାଇଲ ଫୋନ ସବୁ ଛଡାଇ ନେଲେ. So here the omnibus allegation comes. ଅନ୍ୟ ମାନେ who did what in what particular manner is something which is clearly conspicuous, absent. ଆମ ସମସ୍ତଙ୍କୁ ଗୋଟକାଇ. So all the rest of the 5 people,
This is at the FIR stage.
this is at the FIR
You show me
stage.
the charge sheet now.
Yes. Well, charge sheet, most of the charge sheet in the state appears to be behaving in a particular fashion, says all of them against all of them together. There is no, charge sheet begins at page
56. Relevant is 56.
56. Now, before that, I'll show as to the name of the accused, which would see at page, begins at page 33. You may ignore some of the pages to begin with. And please see page 38, 36, Marat, serial number 1 is Suresh Sharma.
Yes.
38, you would find the second one, Pandey. All officers of that particular company, 39 is another. So all of them would be figuring out as the accused. And you won't see the Jindal power on which behalf they purported to have gone to the place is made as an accused. Now, let's see the narration at page 56. On 24th of January, then IRC received.
Come to second paragraph. During the course of investigation,
He examined the complainant, other available witnesses, visited the spot, seized documents. On his requisition, Tahsildar has deputed staff to demarcate the said plot of the complainant. He has obtained the ownership to alleged vehicles. After his transfer, Porida taken up the charge of investigation. During the investigations, he submitted this in the office of LO to clarify the disputed land of the complainant. After transfer of Porida, you may ignore all of them because so many officers have been transferred. And actually, somewhere in the middle, 57 on the top, executive magistrate, Tube, who are present on the day of occurrence near to the spot. Mark the sentence. According to the charge sheet, executive magistrate was present on the spot. Tube was present. Police force was present. And none of them is made as an accused. You have seen the accused list. Only the officers. After their examination, so you don't have to be satisfied yourself with only an examination. If they are present, in their presence, all these acts which are now narrated hereinafter are alleged to have been committed, then surely they are also there.
Do you think all these things are relevant for the purpose of cross-examining people?
Quite right. That's one way. But the other way was, look at my position today. Should I not be undergoing that kind of hassle at that relevant time? Why should I? As I am an officer. And what is alleged against me? For the time being, kindly ignore me not pressing something against Suresh Sharma. But what about others? He himself doesn't say anything against others. And kindly see, my lord, one important facet of this case. 2006, the land acquisition proceeding came to an end. He got the benefits of the land acquisition of the plot, which was acquired for the sake of Jindal power in 2006. He woke up just as a matter of manipulating my company in 2016. It is his own case after 10 years. So after 10 years, the complaint is filed for how much decimil? How much is the decimil that he says? 4 decimil. The idea is to extract some money from a company called Jindal Power. In spite of the fact that whatever is the subject piece of land has already been acquired through due process of law, and the authorities concerned have already given the entire money to him.
What is the stage of trial?
Nothing has happened except
But I don't know, as per the documents annexed by my senior.
It is posted for charge. Can I answer that question if
Yes,
you don't know that?
Yes.
It is posted now for the charge.
After your application is rejected, formal charge will be framed.
Would be framed.
It's a formal charge after rejection,
Formal.
what?
That's
Formal
right.
charge.
Correct.
Yes. Anything else?
Number, you would see narration of events somewhere at page 58. Please see one line.
58. Okay.
58.
Yes.
On my requisition, somewhere in the middle, I obtained the official attested map of the plot number so and so from the office of so and so. So he's involving the land acquisition authorities.
Yes.
I submitted a letter in the office of Tahsildar, sketch map of the plot of the complainant indicating the position of house earlier obtained the same from RTI Tube office. So Tube was consistently being involved.
Right.
And Tube is alleged to have been present even on the day of the occurrence.
Right.
I examined the present Tube,
Hmm.
from the facts and circumstances, investigation, supervision, so prima facie evidences well against the accused persons of this case. The accused persons of the case belongs to one organization on so and so. Jindal Steel believe that they will appear before the court as and when required. Also, as the punishment of these offences is less than 7 years, I submitted in compliance. So all these officers you would find figuring in here at page 58. Now, 917 is the plot number that he makes as if it belongs to him. Plot number 917. I will demonstrate now from the land acquisition proceedings itself that 917 is a plot which doesn't belong to him at all. That is why I said in my opening statement, it is nothing but except complete a case of misuse of the law and just to extract some money from the Jindal Power, my company. We are the officers. It is his own case in the complaint that these officers were sent to the spot, assuming whether the allegations for a moment are correct, on behalf of Jindal Steel. Jindal Steel is not made an accused. But if I am sending somebody, it appeals to common sense. If I am sending this gentleman to somebody's house to commit an offense, surely I am the prime culprit. I should be shown as an accused.
No, what is the test for me at this stage?
The test is it ground, having a ground or groundless? You have seen 239. That is what the magistrate was supposed to do.
The test, according to me, is the allegation which are there in the charge sheet, FIR and subsequent charge sheet, taking it its face value.
Take them as face value. Don't look at my documents.
Whether any case is made out or not.
Exactly. So
And
don't
you
talk.
have a fantastic defense. There is no doubt about it. You have a fantastic defense where this case will lead to a acquittal. There is no doubt about it. But the facts which you are bringing on record, the ROR and whatever documents,
Land acquisition proceedings and others.
and all these documents are part of the charge sheet.
Can I give answers?
If it is not part of the charge sheet, then you can utilize that for the purpose of your defense. I can't get into all this thing and find out conduct a mini trial of kind of situation.
Therefore, my lord, I'm conscious of that position. Let's ignore for a moment the documents which have been filed, the official documents. But let's only see what the complainant
Let
says.
us confine our case to the charge sheet, whether any case is made out or not.
Fair
If
enough.
they not made a particular person accused, the company or whoever it is,
Yes.
they will place the worth of it.
So we'll,
It will be tasted in the trial.
fair enough, my lord. We'll not see the documents which are produced, the official records for a time being. We'll only focus on the complaint.
But why do I'll
And
ask you a
that's it.
personal question to you?
Yes.
Why do you come in difficult cases?
How do you recognize me if I don't come? I won't have.
You are holding such a difficult brief. Anyway.
No, but
Anyway,
I'm
that's the lighter side.
That's right. So the difficulty here is, why should you ask all these officers to have to undergo the difficult process of a trial when there is nothing against me? I have already shown you from the complaint. But apart from Suresh Sharma, I asked that question to myself. Is there any specific act that is alleged against the rest of the accused? No. Answer is no. And why should they be shown as accused here?
149.
149 would be attracted. Look at the ingredients of 149. Only these persons who are present along with the officials of the government. The magistrate was present. Does it appeal even to the common sense that in the presence of Tahsildar, the magistrate and the police officials, all these acts were done only by the officials?
What was happening in that spot? Why these people have gone to their house? What was the occasion?
To demolish this complainant's case is that to demolish in the daytime and
So
to
that perhaps the reason why the executive magistrate, everybody was there, and these people entered inside the house and they have behaved in this fashion.
Yes.
So therefore this FIR.
Why?
That's the story.
Well, the story, I'll tell you the actual story. For the industry to be set up, you require a road, clear road. So that road in any case was having no blockage, except this one. He was trying to extract some money for a small piece of land. Though the land compensation has already been given to the authorities, and he seemed to have had the benefit of that land acquisition. But then he wanted to extract. It is in that sense, how do you explain, Marad, the delay? 2006 is the own case, when he introduces a character of Tube. Tube is with regard to the land acquisition proceeding, which happened in 2006. It is not I am introducing something, a document. Tube, Marad, is a revenue authority.
Dubey may be a very bad prosecution witness. Very bad prosecution witness when he will put to,
The case absolutely is nothing except that he would ultimately ask me to undergo the rigors of the trial for
Let
years
us see
together.
the impugn order. What the impugn order says.
Impugn order. You have asked under my 482 jurisdiction that you examine the evidence of the prosecution and make a detailed analysis of that evidence.
That
which
is
the
14/11/2023.
Yes.
239 application rejected.
You would see
The
in
result
place
of the record reveals that the complainant namely so and so accused complaint against the person.
Annexure 15, it begins at page 108.
My lord, may I draw your lordship attention for a minute?
If with permission of my senior.
No, can we complete it and then you would have the
Yes.
permission,
Yes.
isn't it?
Complete. Yes.
You will see page 109.
109 I am on, 109 on.
Yes, the narration is given, then by my arguments, it has page 110. And at 111,
Yes.
objected the petition, submitted the case was registered and so and so, investigation case is complete, charge sheet filed. From the charge sheet, it is evident that in the period of investigation for a period of 6 years, as if it is in CBI, which is investigating, the investigating officer has vividly and thoroughly investigated the matter by examining all the charge sheet witnesses after visiting spot on several occasions. He further submits that it is evident from the charge sheet that the government officials' witnesses, so the accused have become now witnesses. Anil Panigrahi was present on the spot. Ravi Narayan, land acquisition officer, Padan Naik and Basant Das were duly examined by the IO. IO has seized some documents from them. On the requisition of the IO, joint inquiry of the spot land has been duly conducted in presence of the IO. In reply to the averment made so and so, FPP submitted. It's false to say that prior to that incident, the delivery of possession of the land of the complainant has ever been given to JSPL by land acquisition officer to the IDCO. To the contrary, on the date of the occurrence, neither the LAO nor his representative nor any officer or representative of IDCO were present at the spot for taking over the possession of the spot land. The accused persons being responsible officers without taking help of the concerned land acquisition officer or concerned revenue official. This is wrong because land official is that to be has forcibly and unauthorizedly reached to the conclusion that the land of Dhal is lying in the road, and after their suggestion and self-decision, without any report of the concerned government authority, without any follow-up of the procedure, who else could have been murdered? I asked that question to myself. Without having a government authority, all these officers are government officials. Without any, all the accused persons forcibly entered into the house of the complainant, drove out his family members, with 3 members of JCB demolished his house, shifted the debris, demolished materials by so and so from in order to disappear any evidence of the house. Now, please see, this is the submission of the FPP before the court. Now, if these allegations alone is taken on its face value, it clearly says 2 to 3 things. One, that the government officials were indeed present, and yet they were not made as accused. Second, that the allegation is only with regard to forcible entry, but not with regard to the offences that are now put in the charge sheet. But half of the IPC is put in the charge sheet. And I'll show you, none of the sections, in fact, ingredients of the section is satisfied against me. Now we'll read further. Learned APP relied on the decision of so and so. Coming to the case in hand, perusal of the complaint petition reveals that the complainant made all the allegations by name against the accused persons. Bare reading. So if I wish this statement is correct.
I read 113, I have read.
113?
Oh.
Fair enough. Hence, with the above observation, after examining the material record, considering the facts, circumstances. So all that, my lord, the Lorraine magistrate.
How many witnesses are there total?
Total.
In charge sheet?
Yes.
That's another interesting story, my lord. Please see witnesses. How many of them are there? The total
Total is
number of
40
witnesses.
witnesses.
41 witnesses.
40.
No, I'm sorry. My lord, the total number of witnesses believed to have been present on the day of the incident are 12. Their statements under 161 are annexed here. As opposed to 12 witnesses who say they were present on the spot, the total number of officials who are arraigned as accused are 6. And yet, the allegation is 6 officials, as pitted against 12, made this entire story of forcible entry.
See, that is the reason 319 is also there. If the evidence something else comes against some other officers, they may be also summoned. They will also face the trial. And they've cited 12 witnesses. They may
Not 12 witnesses.
42 witnesses.
40,
But what
yes.
you have examined 161
Yes.
statement, 12
Yes.
person you have taken. You may choose to,
Yes.
you know,
Yes.
read evidence insofar as the 12 is concerned.
Yes.
Maybe 2, 3, you may drop.
Exactly.
Never know. And the only thing what I can do is you tell me, I will expedite the trial to some extent. So that would be the only relief I think in this petition. I can't interfere.
Expedite the trial. Fair
And
enough.
you also know that.
Fair enough.
I'll do it. ଆପଣ କୁହନ୍ତୁ ଆଜ୍ଞା, see, I'll tell you, there are much to say on the prosecution.
Yes,
It's
yes.
very, because of the delay. Delay and the kind of the story put forth is a little shaky, you know. So therefore, I can't go into those facts at 482 stage. So therefore, it would be best that trial should be concluded easily so that these people will be free at least.
Right, right.
Unnecessary a false case appears to have been foisted upon them. And but technically they have to face this trial.
Yes.
So therefore, it is best thing is to do it fast and so that let them go.
Yes.
If at all they.
Yes, yes.
If you can establish the case, that's a different story.
Different.
So you tell me a fair time period so that I can record your statement and finish it
And
up.
charge sheet filed on 15/1/2022. So at least 6 months. complete.
months?
Yes.
But I would only expect that don't ask for extension and I
Right.
make them bound that they will appear, they will not delay.
Yes. Subject to condition that they will cooperate.
If they will delay, if it is attributable to them, this that will not annual
Right.
benefit.
Right, my lord.
Annual to the benefit.
In this case, my lord, 205 was allowed. There was no apprehension of arrest, 205 allowed. Now the case is posted for charge, the 22nd of January 2024. Now, my lord, our application as per the direction of the Honorable High Court to file the discharge application on.
That's right, that's right.
The magistrate took it for 4 months. Or most of the time she was on.
That I could see that. That is
was
the
on
reason
leave.
I'm saying that only I can expedite the
That-
thing so that it is a
Yeah,
balancing
our
act in the sense that whatever apprehension you have rightly, Mr.
Yes.
Tripathi has pointed out, many things, the apprehension is taken care of. Okay, I'll do it.
Problem because ultimately, if your lordship is prima facie found that it will be considered during the course of the trial. And
course.
the trial shall be completed within the stipulated.
The benefit of 205, which was already there, would continue.
That I'll not say anything. I'll
You
not
say, I'll be at liberty.
She is insisting, my lord, for personal appearance.
No, no.
I'll not say, see, I will not control the trial court in what way. You want expeditious trial and you want some, all these things. You cooperate and finish it up.
Make
I will
one,
not say anything on that.
kindly make one
That is
observation.
not the scope of this petition.
That we are at liberty to move on application.
Whatever, I'll
and
just give a little observation to that.
That's right. Fair enough.
See, we have to do, see, I have been telling the prosecutor, we have a fantastic prosecutor here. Neither he or nor me are there to oppose a accused. We have to render justice to them.
Yes.
That is the whole idea of they are also assisting in that patient. I'm also obliged to do that under law. And we are trying to help the accused, not
Yes,
to,
yes.
merely because they are prosecutor doesn't mean that for every drop of head, they'll keep on opposing. They don't do that. So let us try find out a
My lord.
best way of, help the accused persons, if at all they are.
Most of the offences are available and triable by magistrate.
Yes, yes,
And
that-
your lordship
that's-
will
that's right.
directed
I'll-
this case, we will cooperate.
Okay, the petitioner has filed this, the present petition invoking the inherent jurisdiction of this court under section 482 CRPC, inter alia challenging the order dated 14/11/2023, passed by
JMFC Bhorpal.
JMFC so and so, rejecting their application under section
239 of
CRPC. 239 CRPC. Earlier, the petitioners have approached this court by moving CRLMC number shown
593. 593 of 2022.
593 of 2022, and the coordinate bench of this court, which page?
Page 109.
It is
100,
flag mark, my lord.
109 para second.
100,
That order is flag mark.
100,
19/4/2023, order was passed.
109, na?
Yes, yes, 109 para second. Last 3 lines, CRLMC and order dated has been mentioned.
That order is not placed, huh?
Order is flag mark.
No, you just hand
Flag,
it over.
flag, huh? Which
Just
flag?
Hand it
Yes,
over.
yes,
Just
yes.
Who flag?
You can hand it over.
That is flag mark. order.
Yes, yes, flag B, okay. That
Flag
is 593?
Yes, sir.
Yes, sir. While it's order dated 19/4/2023, directed the petitioners to approach the trial court, seeking discharge. Pursuant thereof, the petitioners had moved the application under section 239 CRPC, and the said application had been turned down by the impugn order, by the impugn order. The petitioner seeks indulgence of this court at this stage. I heard Mr. Suresh Tripathi, letter counsel for the petitioner, and Mr. Maharaja for state. Mr. Tripathi has taken me to the record to submit that by taking the allegation at its face value, no case is made out. No case made out. And he intended to point out that the prosecution story itself is completely doubtful, and it appears that the petitioners are fortunately in a false case. He further submits that the revenue record. He further taken me to the revenue record and extract of the award and
You may say land acquisition proceedings.
Land acquisition proceeding, etc. I'm afraid these documents being not part of the record of the charge sheet, whether at this stage this court can consider those documents or not. The next problem, the allegation in the FIR and the charge sheet against the petitioners are agenda. Allegation agenda. The trial court, while dealing with the application under section 239 CRPC, have passed the impugn order inter alia stating agenda. At 112, page 112. Now coming to the case in. Data. Okay. Next program. Mr. Maharaj, appearing for the petitioner, submits that the prosecution has cited as many as 42 witnesses. 40 witnesses, whereas Mr. Tripathi pointed out that only 12 witnesses were examined by the IO under section 161 CRPC. At this stage, this court may not venture into the facts that venture into the record to conduct an inquiry as to why the other witnesses were not examined under 161 CRPC. Next question. Having said that, the only indulgence by this court at this stage could be given to the effect that the trial could be expedited. Even otherwise, the free, fair, and speedy trials, being a constitutional right of every accused person, every accused person, they are entitled to the same. They are entitled to same. In the particular facts of the present case, I am of the considered view that the trial, the prosecution should do well to see that the trial is not hindered, and at the same time, it is expected that the petitioner, being the accused, should not prolong the delay by seeking unnecessary adjournment. Next program. It is accordingly the trial court, namely the JMFC. Trial court is JMFC.
Yes, JMFC. Borpar.
So is directed to expedite, directed to conclude the trial as expeditiously as possible, preferably within 6 months
Yeah.
hence. 6 months.
And since 6 months from the date of production of the certified copy of this order.
6 months from the date of production of the
Certified
certified
copy.
copy of this order.
Yes.
This order. With the aforementioned observation, the present petition is
May
dismissed.
I make one observation, that the petitioner should be at liberty to move an application of.
Petitioners are at liberty to seek all remedy available to them under the criminal procedure code at appropriate stage.
Fair enough.
All remedy available to you. Whatever remedy available to you, take it. I'm not stopping.
May I tell you one thing?
482 count doesn't take it.
So there are 6 accused persons. 4 will appear, some 2 will appear. and
Today you have the facility, the video conferencing facility, lot of facility. I will not control the trial. Once I say speedy disposal, if I will control, then again you will see another application after 6 months. So these people didn't come, so many things, you know. So better that, why should you take on to yourself? Go and appear and finish it up. Finish it up. Looking into the record, I don't think it will take much time. You will be acquitted immediately because the kind of evidence you have.
I hope if that can be the observation. The last sentence.
Why can't I acquit you?
Item 18.
Yes, may I please? It's under section 138 NI Act order, designer of the check mailer. NBW was issued on 15/3/2022 at page 7.
The petitioner has challenged the order dated
15/3/2022.
22, whereby the learned court below has issued NBW against his clients. Full stop. His client, client एक गुटे client है दूसरा client. His client is facing prosecution initiated by the opposite party number 2 under section 138 NI Act for having dishonored the check of
3 lakhs.
Check amounting to 3 lakh rupees. Amounting 3 lakh rupees. The learned counsel for the petitioner submits that his client would be appearing before the
On or
court
before
below on
February 16.
On or before 16th February. 16th February. So next program. Taking into consideration the aforementioned facts, the order dated 15/3/2022 is set aside, subject to payment of
500.
500. Why 500? Every case you have 500. You increase little. 500. Okay.
Item 19.
Same High Court welfare.
Yes.
It's a bail job matter. NBW was issued on 1/11/2023. That's released on bail on
18 huh? 19 huh? देखो, the petitioner has challenged the order dated
2023.
1/11/2023.
2023.
1/11/2023, whereby 1/11/2023. Where is that? Yeah, page. Whereby the court of second additional sessions Judge Bhubaneswar has issued NBW against him. Full stop. He is facing you are on bail.
Yes, my lord.
High Court bail.
21/4/2023.
The petitioner is on bail.
Right, DLA
Bail
number,
from
20.
petitioner has already been enlarged on bail.
Right, DLA PL number 2816 of 2023.
Already enlarged on bail on date. कौन तो ना?
21/4/2023.
21 by the coordinate bench of this court while allowing his
Court
by
below.
the court below. By the court below. Full stop. Full stop. What is the offense?
20B NDPS Act. 20B 2C NDPS Act.
He is facing the trial for offense allegedly committing offense under section so on.
Yes.
The learned counsel of the petitioner submits that he would be appearing before the court on or before
February
15th February and seek remedy available to him under law. Next paragraph. The order dated 1/11/2023 passed by second additional sessions Judge Bhubaneswar in Which case?
इसकी कौन है
In TR case number 87 of 90, 87/98 of 2023. Is set aside subject to the cost of huh?
गंजे केस फाइट कहीं गंजे नो
500.
20.
Mojri kama korji for the yeah, but main job is this.
20 may please.
20?
May I please? It is a Belgium matter, man.
Yes, sir.
On bail, 8/1/2022.
Offense?
Offense
Yes.
person 376, 2N and 6 Foxtrot Act matters. And the NBW issued against the petitioner 6/11/2023.
When you got the bail?
On bail 1/2020.
2021.
Right.
Petitioner is facing trial for having allegedly having committed offense under section
376, 2N, 363 and 109, 31 IPs and 6 Foxtrot.
Full sir. The Learned Counsel of the petition submits that he has already been enlarged on bail on 8/1/2021.
2020.
2020.
2020
8/1/2020. By
the special judge Jagasin.
By the special judge Jagasin. Full sir. However, when the trial was going on, he moved an application under section 317 CRPC seeking exemption from personal appearance, which was turned down by the trial court on 6/11/2023 and issued NBW against him. He submits that his client would be appearing before the court on or before 15th of February. 15th of February. Full sir. Next, taking into consideration the aforementioned facts and submissions, the order dated 6/11/2023 is set aside. Passed by special judge Jagasinghpur in
special JR case number
57 of 2018.
57 of 2020.
नहीं 18 2018
2018 is set aside. Subject to the petitioner paying cost of rupees 500.
21.
May please, lords. The Belgium case, he was on bail petitioner on 8/8/2013, my lord. And offense, my lord, 366 is the major offense. 341.
When you got the bail?
Bail on 8/8/2013.
8/8/2013 bail. Okay. Petitioner is facing trial. 8/8 for offense under section
341, 323. 366, page 10, my lord. 366, 511, 354B of IPC.
The year 19/6/2019. 19/6/2019. 19/6/2019. What gala bhai? 19/6/2019. Yeah. The trial court issued the NBW against the petitioner on 19/6/2019. Full stop. He is in bail and so on so. He seeks indulgence to indulgence of this court. Next paragraph. The Learned Counsel for the petitioner submits that his client would be appearing before the court on or before 15th of February. Taking into consideration the above mentioned facts and submission, the order dated 19/6/2019 passed by the Learned Additional Sessions Judge Dhenkanal is set aside. Dhenkanal in
city case number 17 of 2016
is set aside, subject to payment of cost
1000.
1000. Kahi 2019 order. 1000.
He is
mentally ready
because of first item lordship 19 order 1000 imposed.
But depending upon the delay.
My lord. That's all.
1000. See, bar association, na?
Bar association.
22 copy copy not sir.
Private practice.
Private
copy not.
In
this case, petitioner is a father-in-law. Opposite party is a minor sister-in-law Bahu. Filed one domestic violence case against the father-in-law in the year of 1916. The learned SDM grant interim maintenance. Interim maintenance also challenged by the father-in-law before the session judge as well. The interim maintenance was confirmed by the both courts. The execution proceeding started several times, the maximum tonka paid by the father-in-law. But 2016 to till date, the final case is not disposed of by lingering the Bohu, opposite party number 1. She also working lady by the annex 5. She was job dharma pauchi. But now the condition of the father-in-law is the old man and the medical hospitalized by the
What is the interim order?
interim order, my lord. That is a running page 22, my lord. Ordering person, my lord.
20?
2, running page 22, annexure 2. The respondent number 1 and 2.
22, na?
My lord.
Ah.
The respondent number 1 and 2 hereby directed.
What is your grievance then?
My grievance I challenge here, my lord. The annexure 1, running page 59, 2002, running page 9 to 17, my lord. Everything is clear. ଆମେ maximum ଟଙ୍କା ଦେଇପାରିବୁ ଆଉ ଦେଇପାରିବୁନି ଆଉ 40-50,000 ଟଙ୍କା ଅଛି NMW DW issued my respectable submission case is targeted case ଟା hearing stage ରେ ଅଛି opposite party ଦଉନି ସାକ୍ଷୀ ଆମର ଆଉ କିଛି ନାହିଁ ମେଡିକାଲ ରେ ପଡିଲୁଣୁ ଆମେ ବୟସ 70 ରୁ ଅଧିକ ହେଇଗଲାଣି
it is an interim order.
My lord. But a statute says domestic violence has maximum 6 months case disposal of. Case is hearing stage. Both intentionally got case saruni.
I will target it.
Target it, but till disposal no course of action. I am they can paisa, my lord. How nice that tomorrow double go training here. I'm to both my lord can read the running page 9. Maximum tonka they sir. Bottom hospital.
What was the amount awarded?
Amount my lord 7,000 per month. But ମୁଁ କ୍ଲିୟର କରିସାରିଲିଣି ସବୁ ଆଉ 50-60,000 ଅଛି ଆଉ ଦେଇପାରୁନି ମୁଁ ହସ୍ପିଟାଲରେ ରହିଲିଣି ମ୍ୟାଡାମ ଏଜ୍ ହେଲାଣି ଭଦ୍ରକର ପୁଣି ସେ ଚାକିରି କରିଛି ୱାର୍କିଂ ଲାଇଟ୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ସର୍ଭିସ ମ୍ୟାଡାମ ଆନେକ୍ସର 5
what is he doing?
ଅଙ୍ଗନବାଡି ୱାର୍କର ଥିଲା now is a promoted to supervisor ମ୍ୟାଡାମ
and what is there any issue
ମ୍ୟାଡାମ ଡଟର ଅଛି ଗୋଟେ he is aged about 17 years
17 years what are you doing
husband expired my lord I am a father-in-law, my lord.
Oh.
I am not a husband, my lord. Husband expired.
Father-in-law is aged about?
About, my lord, 70 years above.
70 years.
Mother-in-law be aged about 65 years.
What is he doing?
କିଛି ନାହିଁ ଆମର ବିଜନେସ୍ କରୁଥିଲୁ ଯାହା ଜମିବାଡ଼ି ଥିଲା ବିକ୍ରି କରିଦେଇଛୁ ପୁଅକୁ କ୍ୟାନ୍ସର ଥିଲା ବେଳେ କେସ୍ଟା ଟାର୍ଗେଟ ହେଇଯାଉ ମାଇ ଲର୍ଡ ଆମେ in the meantime no course of action ଆମେ 2-4 ମାସ ପଇସା ଦେଇପାରିବୁନି
she is working then she is not entitled
my lord he is not entitled
might have been entitled from husband not the father-in-law mother-in-law
ପାଇବାର ହାତର କିଛି ରାଇଟ ନାହିଁ he is a working lady but order ଗୋଟେ ସେତେବେଳେ ସେଇ ଟାଇମ୍ ରେ ହେଇଥିଲା
I'll issue notice and stay
my lord
okay
my lord obliged
it's old people unnecessary because the petitioners are the mother-in-law and father-in-law of opposite party number 1. The opposite party number 1 moved an application before the court below under section 12.
12, my lord. 23, my lord. Increment section 23, my lord.
What was the application where the order was passed?
Running page 19, order 23, protection of women and domestic violation to the increment.
Right, but we under which provision?
23 grant करछिन increment.
अरे again आपण execution कथा कहउछन original I am talking about. Where is the original order?
No man execution.
That's the whole difficulty. I want to give some relief but no document would be there.
No annex of 9 hoji order of execution.
I am not on execution, sir. I am talking about the original order.
Original
by which 7,000 is the incremented.
Annexure 2, my lord.
Where is that?
Annexure 2 order pass करते running page 22 रे running page 22.
इच्छी नहीं 2022.
अदार प्रथम से लेखिनी running page 18 रे starting point रे the order arises out of petition filed by the agri person.
under section नहीं 28 ना क्या 23 under section 23 आपको PWDV Act 2005 the learned in ICC case number 87 of 2016 the learned STJM Puri while its order dated 22/9/2016 has directed the petitioner to pay sum of rupees 8,000 petitioners to pay sum of rupees 8,000 as an interim maintenance the petitioner the opposite party number 2 brought in an execution petition being execution petition number 161 of 2017 inter alia alleging that the petitioners have failed to pay the interim maintenance awarded by the court below. While dealing with the said execution petition, the learned trial court, while order dated 15/9/2022, have been pleased to note as under. Page 9, it liquid the total area maintenance amount. Total area maintenance amount पूरा लिखियो इटा को ठीक है लिखियो पेरिफेरल ऑफ द केस रिकॉर्ड इधर लिखियो ठीक है इट लिखियो next problem. Then counsel for the petitioner submits that the petitioners are senior citizen and petitioner number 1 is 71-year-old whereas petitioner number 2 is about 65 years of age. Both of them are bedridden. Both of them bedridden owing to their old age. They are only son.
Only son, my lord.
Their only son.
I would have known you married, my lord.
Their only son, who was the husband of opposite party number 2, has expired after suffering a prolonged illness. Full stop. After the death of their son, the opposite party number 2, with the daughter-in-law, moved this application seeking maintenance. Full stop. The letter counsel for the petitioner has taken me to the record to show that the petitioner, the opposite party number 2, is working as a supervisor, ICDS supervisor.
Opposite partner 1, my lord. 2, no,
Opposite party number 2 is working as a ICDS supervisor. And earning handsomely. So therefore, she is otherwise not entitled for any maintenance. Moreover, being a employed, being a earning independent earning lady, she has no right to claim maintenance from the age-old parent-in-laws.
Father-in-law, mother-in-law.
Parent-in-laws. I have next one. I have perused the record. Prima facie found the submission to be acceptable, and accordingly the order dated order stay courier thila.
Order dated 5/9/2022.
ना सिमिति मागंतु ना आपण the execution proceeding is take करिया पड़ियो.
My lord, execution case होती annexure 1.
हां जे कोन ना आपण
That execution case 161/2017.
Further, accordingly the further proceeding accordingly issue notice to the opposite party returnable within 2 weeks hence. ठीक है next paragraph लिखो the execution proceeding.
Sorry, accept you 161/2017.
Further proceeding in the execution case number 161/2017 is stayed. Till further. आपण execute करी करंतो.
Requisite file Monday.
जब करियो स्टे तो हला ठीक है. late wage diyantu. He is earning, what is the problem?
23.
May I please, your lordship? Lordship, I pray for 2 weeks after, your lordship.
Yes.
24.
My lord, I have already filed the memo, my lord, that I have already filed the memo of undertaking that I will file the English translation of all the annexures which are in vernacular as and when directed by this honorable court, my lord.
What is
Today
this
I have
case?
filed. My lord, this is an application under section 482 for quashing of the proceeding, my lord.
Passing of the, yes. You just ignore that translation. Let us see what is the
Yes, my
alternative case then.
Yes, my lord. My lord, an FIR was filed by the informant alleging therein that the petitioner had assaulted the injured by means of a knife, my lord. But my lord, the allegation is that while the informant was talking with his friends in the field, this present petitioner reached at the spot and assaulted them. Assaulted the injured, my lord. But
You have filed a cross FIR.
Yes, my lord. I have filed a counter FIR, that is annexation number 2.
So both the FIR will be investigated. Who is correct, who is not correct? How will
No, my lord,
at this stage I'll inquire.
But my lord, the FIR against me has been inquired, and ultimately a charge sheet has been filed under annexation number 4, my lord. Alleging offence, one of the offences is 307. My humble submission is that
What happened to the FIR filed by you?
that was not registered even. It has, though it has been.
No, it is registered. There are 2 FIR. You yourself have filed. See, the
Yes,
first
my lord.
FIR is at annexure 2.
Yes, my
and
lord.
second FIR is at annexure 3.
That annexure 3 has not been registered, my lord, though.
Not been registered. Only my lord, the written FIR.
Achha, written FIR.
Yes, my lord.
He has written copy of FIR.
Though it has been accepted by the policeman.
Yes. Mr.
And my
Gupta.
lord, my ground is that my ground is that the injury report of that injured shows that all the injuries sustained by him are simple in nature. So it cannot be under section 307, my lord. This cannot make out an offense under section 307 IPC.
You argue on charge.
Well, that has been already observed while allowing the petition on bail in the law and trial court, my lord.
That's right. Therefore, in the charge stage, you can argue not 482 court for that. What is happening to the FIR, so-called FIR given by the opposite petitioner?
By the petitioner father, my lord. That has only been accepted by the police. Nothing has been happened, my lord. It has not been registered.
Let us seek instruction from the concerned IO.
Yes, my lord.
What has he done about your cross FIR? Okay.
Yes, ma'am.
The Land Counsel for the petitioner submits that he is suffering prosecution after an FIR being registered against him, being FIR number so and so. Okay. So and so. FIR number, FIR number case number 317 of page 16.
Yes.
After investigation, charge sheet has already been filed. He has already been enlarged on bail. Mr. Gopal Mahanti submits that on the same fateful day, regarding the same incident, he has also filed an FIR complaint. He has also filed a complaint before police, which was not registered as an FIR. By way of annexure 2, he has placed on record the complaint. Mr. Ragada appears for the state and submits that he would be getting instruction as to instruction regarding the fate of the complaint /FIR given by the petitioner before the police. Notice Returnable within issue notice, Jagada is notice, returnable within.
That FIR was filed on
Father of the petitioner.
Father of the petitioner. He has also
filed on dated 17/11/2022.
father of the petitioner.
Filed on dated 17/11/2022, my lord.
That I know, that I noted down. Let him get the instruction. We'll see.
Yes, yes.
ଆପଣ 16-17 କରନ୍ତୁ 18-19
My lord, may also direct the London State Council to produce the injury report of the injured, my lord.
He will get everything. 20. But better that you should argue in charge.
20th.
But my lord, on the face of record, 307 cannot be made out, my lord.
That is the charge court will see, not the 482 court at the stage. The court which is framing charge against you, that is the stage where you can raise these objections. Anyway, we'll see. Yes.
Let him.
He's given a date. Which date?
21.
21st. Yes.
May I please your lordship? My lord, petitioner, item number
Yes.
25, my lord.
Yes.
My lord, petitioner bring before your lordship to pass the entire proceeding as well as order of cognizance
Yes.
on the ground of settlement. In the meantime, opposite.
What is the offense?
Offense 376 IPs 506 along with other offenses, my lord.
Foxo is there.
No, my lord, Foxo not.
Settle. What is the terms of settlement? Married.
No, married to each other. They separately, my lord. Gal is also more
They
than.
were married. Wife and husband.
No, they will not marry. A petitioner, because of village dispute, occurrence occurred and a FIR lost and a proceeding initiated against the petitioners. Gal is around aged about 26 years.
That's right, but 376 is there. What is the allegation?
376 is there.
What is the allegation?
Allegation committed. Allegation is that, my lord, committed while one marriage function was continuing at that time, petitioners committed. One of the petitioner committed rape upon the opposite party number 2. Then FIR lost.
Compromise affidavit filed by the opposite party too.
Lordship kindly see already. Opposite party number 2 entered into and affidavit made affidavit before this honorable court and already filed.
No, affidavit all over 376 allegations and which is that village?
Sorry, my lord.
Village is?
Village is, my lord, some Pari Warada within the jurisdiction of Tangi police station.
My lord, I will take instruction from the IO regarding compromise and also the uploaded case diary.
You get
already charges submitted.
No, ideally 376 we should not pass. But again the problem is if she says that I have settled, even if you put to trial, the trial also will say the same thing. So the trial is in futility. That is the.
I will only take instruction regarding the compromise, my lord.
Simply I issue notice to the state. Let us see.
No, already entered, my lord.
No, Mr. Ragada seeks further.
Date may fix, the both will come to the court and file joint affidavit. But if the lordship wants to.
Already affidavit file. Your lordship next week, my lord.
You appear before the IO. Let us see what is happening. Then,
my lord.
IO will order. Shall I dictate or you do it? Write down. It's better that you commit mistakes. The petitioner has filed this petition seeking passing up for the criminal prosecution against him under section so and so initiated at the instance of opposite party number 2. So and so entered appearance for opposite party number 2. Both the councils submits that they have settled their dispute. Under the intervention of the village entries, so as to maintain peace and tranquility in the village, and they have decided not to proceed with the case. Both of them have filed affidavit before this court. Mr. Rogada, appearing for the state, submits that he would seek instruction from the investigating officer regarding the same, Both the petitioners and petitioners,
Petitioners, my lord.
the petitioners and opposite parties should appear before the IO on IO
On 27th, my lord.
on 27th
My lord.
for this month, 27th also. The IO would verify and the
File their joint affidavit before the.
IO would verify the factum of the settlement. Settlement. Both parties are also directed to file joint affidavit. Release the matter on.
May I play one thing, your lordship, not to take any coercive action against the petitioner or something? Because both the petitioner.
Nothing will happen. What coercive action? Who will take coercive?
Because they will appear before the police, a petitioner, so we are not bail, my lord.
No, settlement. What are you talking? They have better things to do. You think that after High Court give direction, you appear, they'll arrest you. What are you talking?
I am apprehending, my lord.
No. Go. No problem.
26. Free copy will be 100. 100 free copy.
Paper copy. Free copy भी दे दो. Yes.
Your lordship, one word is missing, my lord. Your lordship may direct to transmit all the documents to the state council.
If they appear. If they appear.
The IO is directed to submit the instruction and the documents, related documents to the Land Council for the state, who shall produce the same before this court on the next date of it.
Your lordship may keep it in next. First week of
First February.
Obliged, man.
26.
Belgium matter, your lordship. Bail order date 13th January 2022 and NBW was issued on
What is the offense?
2nd March 2023. Offense 397, 450, 294, 307.
Okay, the petitioner are facing trial, na? Or what?
JMFC.
Facing trial for allegedly committing offense under section so and so. Okay. He is on bail. He has already been enlarged on bail on
13th January 2022.
13th January 2022. However, when the matter, the trial court taken up the matter on 2nd March 2023, he was not present.
2023.
He was not present in the court, leading to issuance of NBW. And the Land Council for the petitioner states that her client would appear before the court on or before 15th of February.
May I pay for 20th February?
20th February, okay, 20th February, and seek appropriate remedy available under law. Pulls up on the basis of on the aforementioned facts and submission, the order dated 2/3/23 passed by JMFC.
Banarpal.
Banagopal.
Banarpal.
Banarpal.
On good.
Banarpal in ST case number and then GR case number, na?
The GR case number
GR case
1161.
1161.
1161.
1161 of 2021 is set aside, subject to payment of cost
500 rupees.
500.
Obliged.
27.
Please, my lord. What is it? Application for passing of the proceeding, my lord. It is a matrimonial dispute, my lord. The petitioner is the husband, and my lord, the informant is the wife, my lord.
Settled.
Settled and by pursuant to direction of this honorable court, my lord, both of them are present.
Okay. What is the terms of settlement?
They are staying together, husband and wife, my lord.
Oh, good. Very good. By way of this present, yes, madam. By way of the present petition, petitioner seeks to petitioner being the husband of opposite party number 2, being the husband of opposite party number 2, seeks indulgence of this court for quashing up the FIR number so and so, so and so, so and so. The opposite party number 2 lost the FIR due to misunderstanding in the matrimonial home. Then counsel for the petitioner submits that now the petitioner and opposite party number 2 has settled their dispute. Opposite party number 2 is represented through her counsel, Mr. So and so, for so and so. Both the next paragraph. Both the petitioner and opposite party number 2 are present in the court. They are being identified by their respective counsel. Both the parties have filed the a self-attested copy of Aadhaar card to establish their identity. They have also filed affidavit before this court, reiterating their the fact that
OP2 filed the affidavit. You mentioned that. OP2, opposite party.
You have petitioner is not filed.
Petitioner filed the petition.
Okay, the opposite party number 2, who is the informant in the instant case, has filed a separate affidavit reiterating her stand that she has settled the dispute and started residing with her husband, namely petitioner.
Leading a happy conjugal life also.
And full stop. Presently, they are leading a happy conjugal life. Full stop. Next paragraph. The Mr. Ragada appears for the state and submits that the fact that the petitioner and opposite party number 2 have settled their dispute and leading a peaceful marital life. There is no impediment for quashing the present FIR. Taking into consideration the aforementioned facts and submission made at the bar, the FIR number so and so, so and so, so and so is set aside.
Proceeding
And consequential proceeding arising therefrom are set aside, are quashed. Take it.
28.
May I please, Your Lordship? Here, my lord, the petitioner is a lady. He has, my lord, granted anticipatory bail by this honorable court under Annex 2, my lord, page 19. He has, my lord, she has surrendered before the police, my lord, the arresting officer. But the arresting officer, my lord, after release on bail, my lord, not produced the record before the court, my lord. Though it is a case of 2005, my lord, but part file registered, Your Lordship, kindly peruse page 27. Part file against this petitioner registered and NBW, my lord, since not yet executed, my lord, directed for his production.
Now, what do these NBW need to be quashed?
No, yes, my lord, but NBW, I pray, my lord,
Not
surrender and
Belgium,
it is not a Belgium matter, my lord.
He's saying that he has.
It is not a Belgium.
Fact is, NBW is issued.
My
You
lord.
can't appear and finish.
Yes, my lord.
Why?
Again, Seti
बस काम खत्म. Pay little cost and go and appear. बस finish.
Na Belgium ho कहले परा Belgium.
Bail jump. I'm not writing anything.
Yes, my lord.
Bail jump or what jump? I'm simply saying NBW is issued cost and go and appear.
My lord, within 2 weeks.
Why
my
to
lord.
stall the proceeding?
Yes, ma'am.
When is it? The petitioner is facing trial. Charge sheet is filed na?
मतलब trial charge frame ही नहीं.
Charge framing.
नहीं.
The
trial
petitioner is facing prosecution.
मतलब
In regard to the FIR number so and so under section so and so so and so, comma wherein the charge sheet has been laid down. Charge sheet has been laid down by the prosecution before the competent court. Bail. Are you on bail?
No. My lord, by virtue of anticipatory bail, my lord.
You are there, na?
Yes, my lord. Anticipatory.
The petitioner is availed the concession of pre-arrest bail from the court, competent court of law. However, the trial court on his default to appear on which date?
My lord, on 12/6/2023, my lord.
12/6/2020, 2023. 12/6/2023.
27.
Page.
My lord.
12/6/2023 have issued NVW against him.
Her.
NVW against her. Careful, against her. the learned counsel for the petitioner submits that his client would be appearing before the court
Within
on-
15 days, my lord.
within 15 days, 15 days, next follow. Taking into consideration the facts and submission made at the bar, the NBW issued by the issued on 12/6/2023 by the JMC Udayagiri in
Udayagiri, my lord.
Udayagiri in
GR 101 2005 bracket A.
GR 101 2000 bracket 1A
Bracket
also
A.
is set aside subject to petitioner paying
1000, your lordship.
But it's acid so that a
Absconder. Absconder. Showing abscond. That's it.
তার উপরে উঠলে
only one time.
তার উপরে উঠলে দিও Mr. Ragala appears for the state and submits that the petitioner has avoided the investigation as a result of which the charge sheet was filed showing her
Or absconding.
showing her absconding.
Not arrested and absconding.
She within 15 days লিখলো না কোন লিখলো না কোন লিখলো and avail remedy avail all remedy avail remedy under law avail remedy under law ठीक है
1000 before the trial court, my lord.
नहीं नहीं ये
Yeah.
you enrich your bar
My
Why
lord.
should you?
29 on behalf of Mr. Rakesh Kumar Behra, pray for after launch. One pass.
pass over okay
30. Proceeding in the next compromise reliance.
settlement
Washing on the ground of settlement.
settlement
Offense is relatable to 498 and 494 of the Indian Penal Code.
ठीक है whatever matrimonial
Matrimonial.
ठीक है they are there
Yeah, so
when
I am
will
for
you
the
bring them
I am for the opinion 2 and 3.
will you bring them file joint affidavit when
28 January. 28 is on the Sunday.
28th huh?
Sunday.
28th January where is that
29.
28th is a Sunday 20 bring them out right
I was not at
the parties have settled their dispute and
file the joint affidavit.
they filed also joint affidavit. The counsel for the parties submits that their client should appear in the appear before this court on 29. 29. First 5 meter दे दो. Party जो माने option है ना, you remember don't retain them. सकाल सकाल तक कोई खत्म करो, ठीक है? Don't make them cheat unnecessarily, ठीक है?
31.
29.
May I please? My here the petitioner is the husband of the opposite party number 2, my lord. And the petitioner is a teacher, my lord.
Huh?
Petitioner is serving.
Speak little loudly, or after lunch you have lunch and come so that you get some. Speak loudly.
My lord, the petitioner is the teacher, my lord, and the opposite party is the wife of the petitioner, my lord. And the allegation, my lord, that 498A, 323, 506, and 4 DP Act, my lord. And your lordships can turn to page 12, my lord, that the FIR part, my lord, last 7 lines.
Okay.
First 7 lines, after 7 lines, my lord. ଏହିପରିକି ଅଧିନାଙ୍କ ସହିତ କଥାବାର୍ତ୍ତା ହେବା ଦୂରେଇ ରହିଥିଲେ ଏଭଳି କିଛି ଦିନ ଅତିବାହିତ ହେବା ପରେ ମଧ୍ୟ ଅଧିନାକୁ ଜୋର ଜବରଦସ୍ତ ଭାବେ ନିଜ ବାପଘରକୁ ନେଇ ରାତି ଛାଡ଼ି ଦେଇ ଆସିଥିଲେ 2 ବର୍ଷ ବାପଘରେ ଅତିବାହିତ ଭିତରେ ଅଧିନାକୁ ଡାକିବାକୁ କିମ୍ବା ଘରକୁ ଫେରି ଆସିବାକୁ କୌଣସି ଖବର ଦେଇନଥିଲେ My lord, that the omnibus allegation against the husband, your lordships can turn to annexure 5, my lord. Annexure 5, page 30, and the file an application under section 9 of the Hindu Marriage Act, my lord, for reconstitution of the conjugal rights, my lord, before the family court, Keonjhar, my lord. Now I'm every time open to the now.
Section 9 you have filed.
Yes, my lord. That the Keonjhar, that the family just Keonjhar.
What do you want now?
Let us notice. And your lordships, please just the issue notice to the opposite party.
Is there any chance of settlement?
Now settlement is annexure 24.
I will not say anything. We will simply issue
yes,
notice.
issue notice. Yes,
Issue notice. to the opposite party number 2, Mr. Maharaj waives notice for the state, retainable within for the date to the 20 first week, second week दियो. ठीक है. Settle करके खत्म करो तुम. आसन तो we will ask them to go to mediation and finish.
Yes. Yes.
16th February.
Diplomat.
Item 32. Minor item 32 person. 34.
33 कौन वाला? अच्छा चलो.
Abandoned. Belgium matter, NBW issued on 13/10/2023. 13/10.
32 টা
13 or 30?
30 sir. 30/10/2000.
Bail के वेला.
Belgium matter.
Huh?
Belgium.
When the bail was granted?
Granted by.
Once bail is granted, then only you will jump, na?
Yes, my lord. My lord.
How will you jump the bail if there is no bail order?
No, my lord, accused on bail on dated 22/3/2021.
The petitioner is facing trial?
No,
Yeah.
my lord.
Yes.
Trial नहीं. Charge in, my lord. Charge submitted. Charge in.
हाँ.
সেটা
Petitioner is facing the prosecution pursuant to the FIR number so and so, under section so and so, so and so. He has been enlarged on bail on
22/3/2021.
22/3/2021. On his failure to appear before the court below, after the charge sheet was laid down, the learned court of JMFC 3 cognizance taking court, he pays in year 24. Has issued NBW against the petitioner. Petitioner under next one. Petitioner under when will you appear?
Within 15 days.
The counsel for the petitioner submits that his client would be appearing before the court within on or before 15th of February and seek appropriate remedy available under law. Taking into consideration the aforementioned facts and submission made at the bar, the order dated 30th October 2023 passed by the so and so JMFC so and so in what is this? In GR case number 329 of 2019 is set aside subject to payment of cost of rupees
500.
500 to the High Court welfare bar. कितने अच्छे हो? पासवर्ड दे दो। आओ कर ये रखना 15 इवेंट। Yes.
35.
Please, my lord, I'm appearing on behalf of the petitioner.
I'm for the informant.
Yes, what do you want?
Serving the cup.
It is a contested case.
My lords.
Yes. What is this? What are you asking?
My lords, quashing of the FIR and the investigation thereto.
Will you read it or argue it?
My lords, they have served a counter right now. We'll need some time to go through the
That's
counter.
what I'm asking. If you argue it without, you need time?
My lords.
The learned counsel for the opposite party number 2 has filed the response to this petition today, and copy of the same is supplied to the counsel for the petitioner at the bar, and the counsel for the petitioner seeks time to address the court on the next date of hearing. 16th February.
But it says some interim order. that may be
Interim
granted.
order, if any, continue.
Deeply appreciated.
36.
May it please, Your Lordship. Your Lordship, on the last occasion, Your Lordship had sought for a clarification as to whether the original documents have been seized or not from the state, Your Lordship. This is a case pertaining to delivery of a tractor, Your Lordship. The tractor has been delivered. The allegation of the informant is that only original documents have not been supplied to him. Original documents pertaining to the purchase of the tractor have not been supplied to him.
That's the allegation.
That is the allegation.
And I think it is deposited in the bank or something.
Yes, Your Lordship. Yes, Your Lordship.
Yes.
Sir, I obtained instruction from the bank. I obtained instruction. With reference to above cited above, we have enclosed here with the relevant documents. That is tax invoice, confirmation delivery of vehicle, payment acknowledgement by dealers, and question is submitted the borrower. We have not received any other documents from the
What
dealer.
document?
These are the documents received, my lord. They are given also the documents, my lord.
Hey, what is the allegation? Allegation is tractor is delivered, but original documents are not given. The original documents were given in the bank for availing loan.
No, my lord.
And that is what is the
That
case.
is not, my lord. This month, my lord, the dealer is given to the bank. These are the, my lord, the tax invoice and confirmation.
I wanted to know whether the original documents are there with the bank or you have seized from them and placed on charging. That's the only thing you have to show. If the original documents are there, why should you put someone to?
Original document not given to the bank, my lord.
Then
they have.
And that has been
EC has shown some
Seized from, yes, Your Lordship.
that is in the charge sheet, my lord.
That is in the charge sheet.
That is in the charge sheet.
The original documents are seized by you.
See, not from the bank, my lord.
Or from
the informant, my lord.
Your Lordship, in the seizure list circumstances of seizure, during course of investigation, I seized the above noted articles at Podhadia Syndicate Bank on production by the branch manager Syndicate
the
Bank.
peculiarity of this case is, see, how many dates? 1, 2, 3, 4, 5, 6, 7 days.
My lord.
And we should notice the complainant. Complainant is not coming despite
Not
his
coming,
service.
my lord.
Why he is not coming? He got his truck, he got his original document. He is not interested. Now this
the bank provided all these documents, my lord, which has been seized during course of investigation. Also again, they given the.
You just address me at 2 o'clock whether we can quash this FIR. This is an exercise in futility, according to me. Just address that.
He is coming against a charge, my lord.
Yes, Your Lordship.
What charge? There is
Discharge.
nothing in this case.
For that reason, perhaps the opposite is not appearing, my lord.
Naturally, he is not interested. He got his truck, he got everything. He lost the FIR now, he is not interested.
My lord.
Whether let him face the trial or go to hell.
No.
The documents are already seized by the police.
That's the problem. We should notice particularly. See, March we have issued. And there is a stay of proceeding.
For that reason, the opposite not coming, my lord, since he.
Naturally, he will not come. You just address on this at 2 o'clock. We will see that we can quash it.
Your Lordship.
Okay.
37.
Yes.
This is a case of, I'm in 109 of IPC. My husband is a public servant. Cognizance was taken under section 13(2), 13(1)(e) of PC Act, read with 109 of IPC. I am the wife of the public servant. But here question is, my lord knows, even if some property stands in my name, 109 automatically cannot be attracted.
Abatement has to be there.
Yes.
Yes.
Only materials has to be there to see any type of help or coercion or any instigation, conspiracy, then only 109 will come to play. Here in this case, I have filed 3 registered sale deed. 3 registered sale deed, which is the public document, and the money receipt to show these are my Sridhan property. During investigation, I submitted the money receipt as well as registered sale deed.
When the check period?
That my check period is 1/1/2005 to 11/5/2016. 1/1/2005 to 11/5/2016. 16.
Marriage?
The date of marriage is 10/6/2003.
2003.
Okay.
If you say-
10/6/2003.
So if you say three, then all these acquisitions should be beyond the check period,
Yes.
before the check period.
Yes, my lord.
2005 to 16 is the check period.
Again, 2005 रे, again, 2005 रे
marriage.
check, yes, check period start ହେଲା 2005 रे,
ପାଞ୍ଚ ରୁ
ମୋର
ଷୋହଳ।
marriage ହେଲା 2003 ରେ,
ସ୍ତ୍ରୀ ତ ନେଇଥିଲେ ସବୁ ଗୁଡାକ 2003।
ଶ୍ରୀଧନ ମାନେ ମୋର ଯାହା ଗୋଲ୍ଡ ornament ମୁଁ ପାଇଥିଲି, I sold it, I obtained the lord
Nahin,
money
only
receipt.
thing is three dhan doesn't mean your husband gives you money during that check period, earning wrongly and giving you money.
That is their case.
That can't be.
Yes, yes. That I am in. I am also not in that. But 3 registered sale deed. These are the public document.
Dated.
These 3 registered sale deed will also have a glance to. I have
Falling
given.
under the check period or not?
Yes.
Yes.
Yes, during check period.
Hmm.
These 3 sale deed, the price of 3 sale deed, if will be deducted from the blood's assets, there will be no.
What was your source? Being
Malad?
wife. What was your source?
My sorry, Malad?
Source of income.
My husband is a public servant.
No, I am talking about you.
My source of income. More source of I have
Then
no.
how have you acquired this property?
Yes, I sold the gold ornaments which I have.
These are tribal. These are tribal things.
That
These
is
are
the-
the
that
facts
is-
to be inquired into in the trial. If you can tell me within this check period,
Again.
you have not acquired any property which is subject matter for the DA case, then you are out. Under the aid of 109, you can't be prosecuted. If you say it is a three, then marriage was taken place in 2003.
Yes.
Then the all acquisition should be pertaining to the 2003 before 2005 at least. But the
Yes.
sale deeds are within that check period. You
A
don't
check,
have a
pe-
source of
check
income.
period 1/1/2005.
That's right.
My marriage is 2003.
I know.
After my marriage, check period starts.
How many money you got? According to you, these three then gold ornament were sold and purchased this property.
Yes. I handed over those difficulties. If I handed over the entire money received to the investigating agency, that this is my source of income.
No,
And
purchasing money received.
again,
Purchasing of the gold, that money
now
received.
selling the gold, not purchasing gold. Selling my gold.
Have you checked what is the
So far as the
extent of
immovable, I have already filed my objection. So far as immovable properties are concerned, out of 6 or 7 immovable properties, all stands in the name of the petitioner. So your lordship knows immovable property cannot be acquired. I do admit, thing is that husband can procure asset or deposits in the name of family members. That is not an offense. Obviously, the public father that is not. So far as acquiring immovable property is concerned without consent of the concerned wife.
generally what happens, you know.
That I do admit. Thing is that when the wife
See,
claims that
abatement means he has to abate the husband to
the moment she claims
earn wrongfully. ठीक
Madam.
है? But abatement doesn't take place. In fact, the husband does it utilize the wife to prosecute.
because of that fiduciary
So therefore,
relationship
the
that is
poor lady has no choice.
that I do
The
admit.
husband brings the
I am
money
not-
and
that I
that's
do
the
admit.
whole difficulty.
My lord.
So in that light, you consider whether you can let this lady out. That is I know on material, if you see, she's always in. There is no doubt about it. But what is the prevailing facts in the society?
Usually,
Generally, a corrupt husband has
That's
money.
why I started my
utilize
service.
the wife, get it registered. So there is no abatement.
That is no
as
abatement.
such.
Unless and until she claims that it has been acquired from my sources.
Now
But without having any
has to
source.
create a defense. So in that defense, he can say whatever.
No. The Honorable Apex Court has also held that acquiring assets in the name of the wife or sons or children, that is not an offense. By the public, definitely
Abatement should precede the crime.
precede the
Abatement
crime.
should be precedes the crime. The defense doesn't precede the crime.
My lord.
It is afterthought.
My lord.
So the abatement, see 109, if you want to bring in,
My lord.
then you have to show me some material to show that the wife preceding the wrongful income,
My lord.
she has participated. That concept you bring, then only you can, otherwise we will let this wife go.
That's I am
See,
submitting.
I understand it, but just see the poor lady.
But
Why a corrupt, unfortunately, wife of a corrupt officer. See, in that
maybe
way.
why she should be
And,
liable for
yes.
the corrupt practice of the husband?
And she may not have a say at all in the house. She gets the money, husband gets the money.
That's
procure some property in the name of the wife.
That's why I am
Why
submitting.
it doesn't abate as such?
My lord.
In true sense.
Because sir, तांका relationship रे किए पचारिबो जे से जिनसा करिबो से naturally करिबो the
That's the
children.
whole difficulty. So therefore, we have to look the crime in that aspect.
Thing is that the moment she claims having no source of income, se कहिबो जदि मु मो source करिछि, their abatements comes. Otherwise not.
So that the moment he gives his defense,
During course of
it is not preceding the crime. What is the material you have
That
brought?
period
That,
bhitar
he has abated. He has abated. What is the material you have?
The immovable property.
Abated to
para 10
bring
year
wrong money.
Para 10 year my objection your lordship can listen.
Because you are because he has a
I
defense
got your
today,
lordship's point.
so therefore you can't say that he has abated.
No, that simply on that count we cannot.
So then you show me some material that before the crime, precedes the crime, what is her role? You show me. Precede the crime, because 109 precedes the crime, you have to show the
Intention to
you show me.
intentional aid that is to be 10.
Show me any
Para-
material, then
Para 10 your lordship can listen.
this is the idea is not to
No, move set. I have given
idea is to help the poor lady, in fact, if possible. If materials are there, we can't help. Yes,
your lordship kindly see page 10.
10.
I have given on that
Let
way.
us see, let us see.
That is on
Examine
that.
that line.
That is on that way. No.
10.
My lord.
10 of your petition.
My objection petition.
Objection.
Para 10. He has taken
Yes.
3 pleas. One is the investigating officer has not conducted the investigation properly. That is a matter of trial, that it cannot be. The income received total amount of rupees 7,10,000 out of selling of gold ornaments during check period. The on etiki says gold ornament bikri karchandi boli. The said gold ornament has been obtained from his family and his relation at the time of her marriage, and the original money received by 6 numbers
So
submitted.
all these things will not help. I will only, if at all possible, I will only say that 109 is not made up. But this property will not take out of the record.
Let him file an affidavit that whatever property is there that has been acquired by my husband.
He has to explain that property.
My lord.
There is no doubt about it.
My lord. Let him file on that.
But
We don't have an
whether
objection.
109 is made out or not.
That's why I am submitting. Let the petition, let him submit, file an affidavit that whatever property is acquired that has been acquired by my husband.
How are you? What is this? You will tell the accused to file affidavit against himself. What are you talking?
No, tab nije se husband acquired କରିଛି ବୋଲି.
Acha, you want evidence against harassment by the
your lordship then come to then your lordship ka para 10 I have given
you show me preceding the crime she had a role to play. 2003 to 2005. He married in 2003. The check period started in 2005. Within 2003 to 2005, she had a role to play in instigating for the husband to commit the crime.
So far as instigation part is concerned, so far
how will you grab the 109?
That so far as the intentional aid is concerned.
That is the that's the test for 109.
No, Honorable Apex Court has held that I have not brought that judgment. There, my lord has held that acquiring asset is not an offense. In the name of the that this will not be abated.
He might have done it.
My lord.
Husband might have done it, no
My
problem. This property also he has to explain. That may be his defense. My wife sold the ornament and whatever defense he has. He will face the trial.
That's why.
But under 109, how will you invoke so far as wife is concerned? That is the only
that's why I have
area
given,
where we
in a very fair way I have given my notes of objection. That can be considered. That can be considered. My objection.
We'll put a short date so that on 2nd of February we will examine it.
9th February. 9th February.
Okay, 9th February. But in that light, you have to address.
I have given. On that light, I have given. Your lordship may consider also.
Just try to help the poor lady, that's all.
No, that on that way I have given. He has already out of court.
That's the best job of a prosecutor. If a wrong person is being prosecuted,
That's why I have given.
and you have to help the court so that
I have given objection that.
we'll consider that. That is the only area.
Only.
Statement
ସେ କ'ଣ କରିବ husband କ'ଣ କରିବ କହୁନା କ'ଣ କରିବ husband ତ ଡିଫେଣ୍ଡ କରିବ ନା ଯଦି ଆପଣ ମେଟେରିଆଲ ଆଣିଥାନ୍ତେ ନାହିଁ ଚେକ୍ ପିରିୟଡ଼ 2005 ଆଗରୁ ସିଏ 8 କରିଥିଲା କହୁଥିଲା ପଇସା ଧରିକି ଆସ something of that sort କିଛି sentence some sentence somewhere
affidavit ମାଗୁଛନ୍ତି ଆଜ୍ଞା ଡାଇଭର୍ସ ହେଇଯିବ
ମାନେ ଚେକ୍ ପିରିୟଡ଼ ଭିତରେ ସବୁ ଆକ୍ୱାର ଦେଇଛି ସବୁ ଡିସ୍ପୋଜ ଅଫ କିଛି ଡିସ୍ପୋଜ ଅଫ ଚେକ୍ ପିରିୟଡ଼ ଭିତରେ when she was the wife husband of the man the wife of the man କିନ୍ତୁ ସେଟା statement ସେ କହିଲେ statement is in his favor when we prosecutor has recorded statement in his favor in our favor so we cannot go beyond that so thing is that that's why I have given opinion on that
let this lady go and the husband face you address in that way we'll write
this way this side I cannot say
naturally
so also can consider
that is the fair way of doing it
given my opinion
we'll examine it 9th ଆପଣ ବି ଟିକେ କିଛି ଏଥିରେ ସବୁ କରପ୍ଟ ଅଫିସର ମାନଙ୍କର ୱାଇଫ will be a victim basically is housewife we'll do it 9.
Thursday. Extremely sorry,
Kept
my
it
lord.
at 2 o'clock so that I was thinking that we will finish it up. Okay. When is he
My lord, he-
available? You tell me.
25th Thursday, if it can be listed.
7th or 8th?
7th,
8th will do.
my lord. Is there any Thursday, 8, my lord.
8th will do.
Will do, my lord.
Okay. 8th.
Grateful.
And, yes, no problem. Yes.
Okay.
Are you saying something?
Method, how do
Yes.
Yes.
Is he saying something? No.
That is the question. ठीक है.
Okay.
Well, it is that.
40. Yes.
Look at the order of convenience taken on page 68.
Yes.
ଆମେ କଣ କରିବୁ ଆମର କିଛି କାମ ନାହିଁ ଆମର ଆଗରେ କଣ କାମ ଅଛି 468 ଟାକୁ
68, huh?
ଲିମିଟେସନ ଗ୍ରାମ
Okay.
ଏଟା ନେଇକି ଦେଖ
Yes, sir.
टाइम लॉट वेरीफाई करो 468 के कॉलम हिब्रा नहीं है
1A and B and 73 of the Mines Act received from the Director of Mines Safety. DPMS Southeastern Zone Ranchi along with the petition seeking condemnation of delay due to the ground stated therein. As the limitation period of taking cognizance of the offense of section 72C1 A and B and 73 of the Mines Act has already lapsed. As stipulated under section 468 of the CRPC, it is conducted.
How will you invoke 468? 468 is something. A special statute you are bringing 468. What is it? 468 is also.
But 79 is the limitation prescribed under the Mines Act.
Right.
There is a specific provision for the limitation. And how can the CRPC be attracted to?
How for the purpose of condoning delay in taking cognizance, can you employ the general law when the special statute is invoked? What is your answer?
That point, my lord, 68 CRPC, may pray one thing, my lord.
No, you have to assist. This is a question of law.
This is a question of
raising
law.
Very
This is the question of
important.
law. So by
Come to 468.
yes, my lord.
On 468.
Bar to take cognizance after lapse of the period of limitation. First, expressed as otherwise provided elsewhere in this code, no court shall take cognizance of an offence of the category specified in the subsection 2 after the expiry of the period of limitation.
So the specification is only the 468 is operative insofar as the category specified in 2. See what are the category?
The period of limitation shall be 6 months if the offence is punishable with fine only. B, 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. C, 3 years if the offence is punishable with imprisonment for a term of exceeding 1 year but not exceeding 3 years.
For the purpose of the period of limitation in relation to the offence which may be tried together shall be determined.
Shall be tried together.
Yes.
Shall be determined with the reference to the offence which is punishable.
No, if the general provisions are invoked, IPC and all, you can employ this provision. The question is if the statute provides a strict limitation, can you employ a special law and ignore that statutory provision?
On that point, my lord, that is the only the question of law, whether this 460 is applicable.
You assist us, that is the question of law.
That.
See, if the statute provides a specific limitation,
My lord.
you can't what you call sabotage that provision by employing a general law.
For that reason, I pray from.
Then that provision is redundant. Then.
For that reason, my lord, I pray some time to verify actually exactly that whether that 460 is
Control of some law to support your case. Otherwise, I'll quash it.
No, there is no. I have checked the there is no.
That's why I'm saying let it come.
Otherwise.
No, this is the proposition, simple proposition. The statute provides then the purpose of the statute is diluted if the general law is employed.
That's true,
Well,
my lord.
Your Lordship, may I
But-
kindly have a glance at section 79 of the Mines Act, which prescribes the limitation. And the language used.
79, huh?
79, section 79 of the Mines Act.
Mines and minerals.
No, Mines Act.
Only mines act, I think.
No court shall judgment of any offense under which are unless.
79. Yes, limitation.
Thomas Parayoj.
No court shall take cognizance of any offense under this act unless complaint has been made.
Further need not be read. Under this act, this provision act.
No court shall be cognizant of any offense under this act unless complaint thereof has been made within 6 months of the date on which the offense is alleged to have been committed, or within 6 months of the date on which the alleged commission of the offense come to the knowledge of the inspector, or in any case where the accused or was a public servant and previous sanction of the central government or the state government of any other authority is necessary for taking cognizance of the offense under any law for the time being in force within the 3 months. So that's why I play some.
It is if it is a government employee.
Yes, in case where a court of inquiry has been appointed by the central
That's not
government.
the case in this.
The inquiry officer is appointed here in the case. Appointed. In this case, inquiry has been appointed, inquiry has been made.
Inquiry by mining safety is not a
Section
court of
24 of within a
1 year.
Under section 24.
well, after the date of the publication of the report, upon subsection certain such.
1 year.
So I pay some time to
Where is
verify
court
whether
of
there.
Inquiry, my lord. This is an ordinary inquiry by the
No, no.
mines.
Section 24 says that the power of the government to appoint a court of inquiry in case of the accident and all. That excludes, that part will not. Maybe you have an answer. Is it a government officer? He is a government officer?
Yes, government officer.
No, he is a coordinating officer. How can he be a government officer?
Employee of the MCL.
See, insofar as mining act case, whether government officer is defined under the act. Who is an officer? No, it is not defined.
Yes, the 53, the complainant Union of India depends on the Sunnik Ratnakar, designated Director of Mines, officer at South Eastern Zone, Director General of Mines. So the complainant is a government officer, central government. That's why I am paying for time to whether the verify that whether the 468.
All right, you take, well, you may have an answer in this exception.
My lord.
You may have an answer in this exception and examine whether it is a continuing offense or not. These are the two answers you can find out. But prima facie, I have the view that if the special statute provide a limitation, you can't employ a general law to condone it. You have to find your answer in that provision only, 79. If you have answer on 79, then it's all right. Otherwise,
He has also not exercised power under section 79.
That's right. He has employed 468. Prima facie it is wrong. But if you have an answer on 79,
my lord,
if it could be condoned on 79, I can remand it back. Or do you want that I'll set aside and remand it back to apply the mind on 79? That's the best idea. I'll set aside and remand it back to the trial court to decide the question of limitation under the aid of 79.
He has already held that it is barred by under section 70.
79 will be applicable.
79, he says that it has lapsed.
So I will verify on that.
Where is that?
Let it come.
Let him file an affidavit.
You file an affidavit. Taking time, 1 week time.
1 week.
My lord.
2 weeks.
1 week time. 1 week after my lord.
तो आपने जब convenient rate.
15th February.
Yes, my lord.
15th or 16th?
16th
February.
16th February.
Interim order.
Interim order to continue.
Interim order, hey, your lordship wanted to hear them first.
No, sir, ये आपको prima facie तो case कौन सी interim order?
That on 16th, my lordship can dispose of that's nothing.
But he will move application and for adjournment.
The order
application
order টা হচ্ছে 30/10/23 ର। So
Stay of further proceeding till then.
so he might have been appeared in the case. 16 ତାରିଖ ତ ଆସିବ that date my lordship can be remanded.
Right. It will stay till then, may not 16th date. Why should these MCL officers attend? There are other points also I am satisfied with.
Arjun application, let them to file Arjun application.
General manager वगैरह कर देखिए अपन को कौन होती सेंट्रल गवर्नमेंट लेके अपन
हमको कॉपी दे दो।
जनरल मैनेजर तो सामने कर दीजिए ना।
देखो Mr. Ashok Mohanty, appearing for the senior advocate, appearing for the petitioner, submits that the court below. Where is that cognizance order? Is
page 68.
16, 16.
68.
That is 68. Here. Submits that by way of impugn order, the court below has employed the general provision provided under 468 CRPC to condone the delay for taking cognizance of the offence under section 72 capital C bracket 1 bracket A and bracket B and 73 of Mines Act 1972. The Mines Act 1972 provides a specific has a specific provision
52
under section 79 for providing limitation. He submits that if the special statutes provide the limitation, general provision cannot be employed for condoning the delay. Land counsel for the opposite party seeks time to address on this issue and seeks 1 week time and 1 week time. At this stage, senior Mr. Mohanty senior counsel seeks interim direction for staying the further proceeding before the court below.
In 2CC case number
on 2CC
24.
case number also. I'm of the view that the case is at the very threshold. Therefore, the petitioner may move appropriate application before the trial court for adjournment. The same shall be considered by the trial court, keeping in view.
Appear we have not appeared.
You have to appear in the case.
Why should I appear?
Keeping in view the pendency of the case before this court. Simply without appearing, you can move application through counsel. Through counsel.
My counsel first date appear the Mina. Complaint case to for
30/10/23 order टे
ଆପଣ adjournment ମାଗନ୍ତୁ. If otherwise I'll stay. You can't have both. Otherwise argue it today. Because see, the problem is you ask for time.
On their point of law, I can.
The opposite, Mr. Mohanty, Mr. Mohanty submits that to the court decider. At this stage, No, I am you got that. At this stage, so and so. No.
Mr. Mohanty senior advocate take interim direction for save the further proceedings before the court will not. In 2CC case number.
So at this stage, at this stage, the legal counsel for the opposite party submits that he would
opposite party complainant
said that he would seek adjournment before the court below owing to the fact that the matter is sub judice before this court. You seek the time.
This matter will be called on
No, 16th.
16th February.
February. Already, it is convenient to you or otherwise?
Any day that is convenient, but it is a pure question of
Pure
law. It
question.
can be disposed of.
You find your answer
My
in
lord.
that.
Disposed of by asking, demanding it and asking them to
Yes.
decide.
That thought today also I could have done it. Set aside, send it back and 79, apply 79 and decide that.
That I agree, but this is the-
On that, my lordship can dispose. Oblige.
That also I'll do the same thing. What is you? My lord. Anyway.
29.
29. The reverse kind of passport. 39.
29.
Arjun, what do you want?
29. Well,
Huh.
29 in this case, I have instruction to appear on behalf of office number, OP party number, office number 2. I prefer some time to file the Vakalapnama.
What is this matter? Settlement?
Passing of the question.
Your lordship, as a educated person, your lordship on sympathetical ground granted stay. This young man was conducting. the case.
What happened in that case? Just remind me.
In that case, the allegation was that electricity officials had come to the house of the present petitioner. While they were checking the meter, the present petitioner, there was an altercation, and on basis of that, 506 IPC has been.
What do you want? What is this?
Yeah, appear
Small
Koran,
matter.
he has been instructed to appear.
I will only
So let him to appear.
So put it on first, second, somewhere. Second February.
Yes.
Come with instruction.
Fine.
It's a very small matter.
32.
Yes.
Cognizance.
Cognizance.
Order of connection. 6 page matter 78 order of cognizance matter. The London court below that following the procedure of law matter has taken cognizance on the basis of only statements, not in the following the procedure of 200 statements. Without matter, the statement has been also can on to page 76 annex of file.
It's a complaint case.
Yes, complaint case. Only an affidavit filed by.
That pre-summoning evidence only affidavit.
No, that you also kindly see. Here is a
For
complaint.
pre-summoning only, you will not get an opportunity to cross-examine. After
Matter
summons
that
are
will
issued.
be before the magistrate in the form of oath matter. 200 CRPC, they have not.
Oath commissioner he might have placed before oath commissioner.
You also can, well,
Where is that affidavit?
Annexure 5 page 76. So the advocate has filed the affidavit. They have treated it as an initial statement matter without taking in oath matter.
No, Rajguru is the complainant. Rajguru has given it 76 HC attested by the oath commissioner. Okay, yeah.
Your lordship can that
Attested by oath commissioner. Also, your lordship may kindly turn to page 79.
and your lordship can
That is also written.
200 CRPC your lordship can see.
Sabu
Well,
achi
my
chita.
lord, a magistrate taking cognizance of an offence on complaint shall examine upon the oath of the complainant and the witness present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also. by the-
Are you really seriously arguing this matter? Do you know the practice? You know very well.
Well, here for 138.
You read 313. What happens 313? No. In 313 nowadays they give the what you call pen drive.
Then
Because
in 138, that should be here, they have the fact of the lordship come to say. The lordship, the background. of
ଆଉ
the
ଗୋଟେ
case-
କେସ୍ ଫାଇଲ ପୂର୍ବରୁ ଫାଇଲ ହେଇଥିଲା ତାର ନମ୍ବର ବି ଦିଆ ହେଇନି ଗୋଟେ CRLMC ନମ୍ବର
କଣ ହେଇଥିଲା ତାର?
ନମ୍ବର
ନାଇଁ, ସେଟା ଯୋଉ affidavit ଟା ଜଣେ ଯୋଉ ଫାଇଲ କରିଥିଲା ତା ଯୋଉ ପିଟିସନର ଫାଇଲ କରିଥିଲା, they are stated to file the affidavit by the father because he was staying at Canada. That's why the application was withdrawn. That is in order city.
What are the offences?
My lord, for the offences, sir, 294, 323, 365, 506.
You come from Canada and
Yes, here my
beat people and go back.
Here, your lordship kindly see. Here, my son is at my father-in-law has filed the case. It's a peculiar case, my lord. Lordship kindly see.
Father-in-law, you might have gone to father-in-law
No,
house
my lord.
and
Yes,
attacked
my
them.
child is there. Custody has been declared. Your lordship kindly see. The judge family court has declared the custody. Your lordship pays to come to 74. The custody of the child has been given by the.
I can only do one thing. I can issue notice. Don't ask for interim of direction. Okay, issue notice. I'll just see because it's a matrimonial dispute. Let us see
Yes, yes,
if something can happen. Issue notice to the opposite party number 2. Mr. Maharaj waives notice for the fund returnable.
Also in the miscase, I have filed a miscase. That on miscase also notice.
Issue notice on main case as well as
Miscase.
entry. Oh, yes.
And my lordship, I will file an adjournment petition that.
My urgent person came.
You very safely,
Proceeding has taken.
you are in Canada, you came and create hullabaloo there in your in-laws house and go back.
Yes.
And I have only, what has persuaded me to issue notices, it's a matrimonial dispute. Let us see if something can be worked
Yes,
out.
I have brought the child to for study at Canada because the family court has directed and also a case direction has been given to the police to.
But these are not the scope of this petition.
So this is the case background of it.
Will I just
Father list I am giving 30.
let us see if let them come. We will try to settle all the dispute together. Let them come.
My lord, in item note 29, there is an interim order that may be continued.
That will continue. But
36.
And notice by it.
Yes.
On that matter, my lord, in item 36, my lord, the accused persons are two brothers, my lord. Accused persons, two brothers, my lord. They taken some signature of the informant in blank papers and applied for a loan in respect of a tractor, my lord. And the all things, my lord, they send this.
They took blank paper signature and applied for loan.
Loan
for tractor.
And bank the
bank
of rupees 5 lakhs, my lord. Bank syndicate bank stated that they have to give up to 4 lakhs, and the accused persons have to pay 85,000. Thereafter, they given DD of rupees 4 lakhs 85 lakhs to the accused persons. The accused person dealer of that tractor, my lord. Thereafter, they deliver the tractor to the informant.
When 480 was paid.
Paid to the seller of the company, my lord. Thereafter,
the accused person might have paid 85 from their pocket.
My lord. No, the accused person is the dealer, my lord. One of the dealer and another the sales agent. Two brothers, my lord. And what happened in the meantime? They delivered the tractor. The complainant has to pay the loan to the bank, my lord. And thereafter, they did not register the vehicle in the name of the petitioner without giving the sales certificate. And the accused persons, my lord, given the sales certificate to the petitioner so that he can able to register the case in the RTO. That till late that has not been registered. And that only that reason, my 424/71 registered against the case registered and charge sheet submitted. And the documents which are seized, my lord, during course of that is some bank documents, Xerox copy, tax invoice and other materials, my lord. Till late, for that reason, the complaint issued send a advert notice to the accused persons. Please give me the sales certificates, or otherwise you register the vehicle and give them.
Two brother, one is the
proprietor,
and another is the sales person arguing. Why don't you give sales certificate where registration will be done?
That the person is claiming of, that is being paid by me only. When the bank, that is on record, the bank has issued a letter to National Voters, that identity proprietor, saying that you have to deliver such and such documents. And I have also written a reply to the said bank saying that the original papers have been delivered to the person itself, to the informant itself. Now the informant says that I have not received any of such documents. This is one part of the allegation. As far as 471 is concerned, Your Lordship, even if admittedly I have taken some blank signature, some blank paper, Your Lordship. That signature I have used it in confirmation of delivery of tractor by national notice. The delivery confirmation that I have given you. Where is the question of forging the documents arises, Your Lordship? The property in respect of which it is alleged that I have cheated. The
Now you tell me whether the tractor or truck, whatever.
Tractor, my lord.
Tractor is registered or not?
No, till it are not registered, and that is with the informant, my lord.
That is
They keep,
But he is not able
not
to-
utilizing itself.
He is not able to register because the original document is not there according to
My
him.
lord. Now, for that reason, nowadays, my lord, even if one person want to purchase the vehicle or a tractor, registration along with registration, all the things given to the by the to the purchaser. By the time, 2007 case, my lord, by the time the seller, my lord, has to obtain the RC book and etc. from the RTO office and give hand over to the purchaser.
Tell the IO to serve the.
I was given the, my lord, one page, my lord, the
informant.
My lord?
Tell the IO to serve the informant, bring him in.
My lord.
Despite repeated notice to the opposite party number 2, the opposite party has avoided appearance before this court. Before this court. Therefore, Mr. Ragada states that
IAS may be directed.
He would be serving the opposite party number 2 through the IIC. Which police station? IIC so and so.
Udala.
Huh?
Udala.
IIC Kodola.
Udala.
IIC Udala.
IIC Udala may be directed to produce him in before the court.
IIC Udala directed to
cause production of the
inform the opposite party number 2 regarding the next date of hearing and अरे सिमती कोई तो वारस पास करी उठी इधर के भी
ना से दाके उनते
झंझट पुलिस वालों को झंझट ना दे
इन्फॉर्म कर ले आसी उन्हें पुलिस
सर उल्टा पड़ी वो कंप्लेनेंट इज इन एंड एक्यूज जॉली वेल रनिंग डोंट से दैट दैट्स वेरी डेंजरस
वाले मानी बनी आगे आसी बनी
So बांधे भी दिपक नहीं.
ना ना कहा जो आसी पॉजिटिवली
what have you written next date of hearing and ask the informant to appear before this court
positively
on make it 6th of February. Okay, 6th of February. Okay, without fail. Without fail, let us see. Let him come.
Free copy.
Let him come.
Free copy may hand over.
Free copy. Let him come. What we'll do is, if the originals are there with the police or you hand it over, he will register, you quash it.
And another thing,
the problem is solved, his problem is solved.
If you will call the also the petitioners, here also the matter is settled.
Call your client also.
Everything.
And meanwhile, verify if the original is not there. If you can issue a duplicate in the suppose original is missed, duplicate also can be given. On that basis, registration can also be done. Why don't you bring a duplicate? We'll hand it over and
another thing, if the IO will be, if the IIC will director will appear on that day, must procure all these documents and also the accused and petitions.
He will come with a duplicate. Suppose the original
invoice
it is lost. Generally, we get a duplicate. And IO indemnity and
your lordship may say IO will appear on that day. IIC will appear on that day.
The
IIC also.
IIC will also appear before this court through VC on that day.
VC.
Interim order to continue.
38.
Take it. What's up? Take any day you want. Date we will adjust. Date we will adjust. We that much. Yes.
39.
39.
In the case I have already appeared after getting notice from the son of the opposite partner 2. Some time to take instruction.
What? The settlement matter?
Not settlement. It's a cognizance matter.
Copy then.
Under section 420 that has been challenged.
220. State is not a party. Complaint.
No.
Complaint.
Complaint. Yes.
What is the allegation?
Today I got the documents from my client.
Oh, short date the name. Mr. So-and-so appears for the opposite party sole opposite party, yeah? And 6 time. Entire appearance in 6 times.
Already on record appearance.
17. Entry mode to continue. Present, is there? No, yes. Oh, this one. Cancellation, bail jumping. Special. What?
Item 1,
Sanjukta call. What is this matter? Huh? Yes. Hmm.
The cognizance has been taken on section 406, 420, 506 by 34 in section 323 of SQ and STP. Present case is madam, I thought civil case. Previously, a civil litigation was filed. In that case, madam, they failed to get any interim order. After that, madam, the present FIR is still lost. In the FIR allegation, madam, there is no allegation of the ACSP, madam. Case 13, madam, in the FIR. That I being a number of caste, beginning to SC and taking advantage of my caste, the vendor are playing with my rights and harassing me.
What is the stage of?
This is the allegation of.
No, that's right. What is the stage? All these things you raise in the appropriate stage. What is the cognizance order? How can you challenge all these things? You bring whether he is SC, not.
Since there is no case is made up on the section 3 and.
No case is made out. Test is in at the stage of. You land counsel for the petitioner seeks to withdraw this petition. And you know how cognizance are taken. You know that.
Yes, madam. In a non-speaking order, madam, he has passed the order, madam.
That's right, but you know, charge sheet is filed, cognizance is taken. There are steps. You can move an application for discharge, argue everything, point it out, and 482 court will do all these things. The problem is you are converting 482 court to a cognizance court.
No, madam. As per the judgment of the.
You are absolutely correct. I am not on that. I am not on that. But you have a court of first instance should apply the minds.
By disposing the bail application, this honorable court has also the same thing. It is the bail application.
No case is made out. No case is made out.
No case of PSFP is made out. Considering that aspect, the bail was granted.
And then therefore you should be discharged from 3.
I didn't say that. I may be disturbed from the SCST offense, not that the whole offense, madam.
No, that's what the court, trial court will do. I just.
City consider have na
I observe that. Mr. Mishra, the present petition is filed challenging the order dated. Order dated. No. Order dated. I'll give you a better relief. Order dated. You have not in the prayer. You have not written order dated. There is no order dated. Huh? Which is the order? What is this? People are very casual in drafting. Huh? At least in the prayer, at least you will write or not. In the prayer, there is nothing. Order dated 7/6/2023. 23 passed by Special Judge Raigada. Whereby cognizance of offence under section so ACST 49 page 49 has been taken against the petitioner. How many petitioners? Petitioners has been taken against the petitioners. Mr. Mishra, by relying upon the order dated 29/11/2022 passed by the coordinate bench in ABAPL 14606 of 2022 submits that even while granting bail to one of the accused, the coordinate bench has observed that no case under ACST Act is made out against the petitioner. He strongly relies upon which para? He strongly relies upon, huh? No, I am this Lal case we first talked about. This, where does it say that no case is made out?
My contention was accepted by the court.
Where is that? Where contention?
Second part.
Contention?
He strongly relies upon.
Para 3, 4, 5 of the said orders, which reads as under. Further, Mr. Mishra argues that accepting the allegation at its face value, also no case under SC/ST Act is made out. So therefore, by employing the ruling of the Honorable Supreme Court in Bhajan Lal, so and so, exception, which exception? Bhajan Lal, which exception? Which exception of Bhajan Lal? I will do that, or you will do that? खाली भजन लाल बोल देने से भजन लाल थोड़ी हो जाएगा. There are exception. You tell which exception you are falling under. हाँ, under Bhajan Lal, no case is made out. No case is made out. This court, while exercising jurisdiction under 482 at this stage, need not go into all these points raised by the learned counsel for the petitioner. However, he has liberty to raise all these points before the trial court at appropriate stage. Therefore, this court is not inclined to entertain the present petition. However, granting liberty to the petitioner to raise all his points at the appropriate stage of the trial. With this observation, the petition is disposed of. Bhajan Lal exception, you tell.
Item 2.
Which exception in Bhajan Lal?
Item 2, 5301 of court.
Item 2, my lord, Sri.
No, it's all right. You tell what is this matter.
My lord, here, my lord.
Cancellation.
No, my lord. That matter is also.
May I please, my lord, I am appearing through VC.
Next 2 matters are cancellation of bill.
This matter needs to be heard. You told me that the cancellation of NPW. So therefore, I said, okay, at least it's small matter. You want a full-fledged in a second supplementary. You want a full hearing in a matter. Huh? Obviously, he will see.
The second.
List it on 1st February.
My lord, 24 is an appearance date before the learned court will open. If the petitioner will appear, then he will face the results of.
What is the offense?
The offense is 294.
May I, my lord?
Yes. What is the stage?
Am I audible, my lord?
Yes. What is the stage?
Is this 5-3? This is say I have filed. Lordship, kindly see. I have filed this court. My only case, my lord, is that there is nothing against me as of now. Prima facie. Am I audible, my lord?
Yes, I can hear you.
Please tell
me.
Nothing is against me, and why should I be put into the trial? That is my only thing. My lord, I am an officer, Navy, my lord. Navy NCC, I am an officer, my lord. Once I appear before the court, the entire career would be at stake.
Let us, my lord, let a argument be made. I am ready.
So I'll just satisfy your lordship with 3 things, my lord.
If you make out a case, then I'll interfere. Otherwise, yes.
I'll try to satisfy your lordship, my lord. I know on 482, like your lordship would be seeing, my lord, whether there is a substantive
you are
justice
challenging
to
what? Cognizance.
No, I have been. What in this case, my lord, is
what is the stage of investigation?
Charge sheet has been filed. Charge sheet has been filed.
Cognizance has been taken.
Yes, charge sheet has been filed. He has been annexed the charge sheet. Charge sheet page number.
Yes.
Yes.
Lordship, charge sheet has been filed.
Yes, that is 32, page 32.
Page 32 is the charge sheet, my lord. This is a magistrate tribal case, so.
Yes.
So 239 would be the thing.
Page
So I
36.
will not get much opportunity. If I have to lead defense, my lord, that would be at the very end of the 313 at that stage, my lord. At this stage, it would be only on 239. So a kind of summary hearing kind of a thing. But what has happened in this case? I have three grounds on which this 482 has been filed. One, my lord, is I am claiming alibi on that particular date of incident. My lord, I was not there in the spot at all.
That is the plea of alibi could be tested in the right stage. Plea
Right
of alibi
stage,
in
I
the
agree.
482 I will not
I
examine.
agree. On prima facie, lordship is to see whether I should be put into trial or not. Your lordship may kindly see the movement order at page 14.
14.
Page 14 is the movement order.
Let's see the 14, page 14.
1-4 and 1-5.
Yes.
1-4.
Yes.
1-4 is the movement order, my lord. The
Yes.
alleged date of incident is 3rd April, my lord. And if your lordship comes to the bottom, my lord, from 30th March to 4-4, I was almost
Where is
250 kilometers away from.
Where from you got that 3rd April?
If your lordship comes to the handwritten thing on the bottom of the page, my lord. Manoj Kumar Mahapatra reported at this college on 30th 3 2022 and departure from this college to his unit on 4/4/2022.
Right.
So I am making a very limited prayer at this stage, my lord, that at this stage, I am very sure lordship is not going to quash it at this stage. Now that these new documents have come up, they say that in 41 they called me, but they've never called me. And if your lordship sees the date of FIR and the date of filing of charge sheet, it has been filed in a very hurried manner in 20 days' time.
If the investigation is done very expeditiously, you have problem. If
No,
it is
that's not the
delayed out,
problem.
you have problem.
I'm not saying
And
that,
you
my lord.
should
I'm
give
very
credit to
happy
the
that it
police.
has been
Sometimes
done.
police does a good job.
But question is that, my lord, when they've said that they've called me, but they've never called me.
Mr. Maharaj,
Yes.
what is the allegation?
Allegation, my lord, the complainant has stated in 161 statement that मनोज महापात्र रविन्द्र दास सहित सबुबेले कली झगड़ा करे और तांकर मिक्सचर फैक्ट्री को सबुदिन ପାଇଁ बंद करने को धमक दिए ता 3/4/2022 लिख रात्रि प्राय 12 घंटा समय मनोज महापात्र रविन्द्र दास घर निकट को आसी अश्लील भाषा गाड़ीगुलज कला और जीवन में मारिदेवा को धमक देला दिस स्टेटमेंट हैज बीन दिस particular statement has been corroborated by all the witnesses. Those have been examined during course of investigation. Accordingly, charge sheet has been filed. That is the specific provision page. That is the page 36. Your lordship may kindly 6. Page 36. It has been clearly mentioned that what he has done, and accordingly, prima facie 506 and 294 is obviously made out. What is wrong in that? And the question is that whether you are present or not, that only you have to plea, you have taken or plea at the time of trial. That cannot be adjudicated at this stage because this charge sheet has been filed.
I'm grateful to my learned friend for taking your lordship to page number 36. Lordship, I kindly come to that 161 statement, my lord. Lordship, I kindly come to page 37 is the
No, I will
161
not go
statement.
into 161 at this stage.
No, I'm
But
not
you tell
asking you
me if
lordship
you
to
got
go into
it.
that.
No.
What
A
I'm trying
482
to
go
make
into
out is that who are these witnesses? These witnesses are those persons who have been
Why don't you settle
accused
this?
in another affair lodged by me.
Settle कर दिया.
Settle करो.
506 settle कर दिया.
506 settle करो. What is this big thing?
They want to harass the.
I only can help you to the extent that I will issue notice to opposite party without saying anything.
Only prayer, my lord, is that
No question.
only prayer, my lord, is that
Write down.
24 if he appears, my lord. 24 lordship, give me another 2 minutes, my lord. I'll just show you, lordship, who is this witness. Page 37 again. Who is this witness? 161 statement, my lord, has been read out. He is the person, my lord. I have, lordship, kindly bear me for a moment. I have filed an FIR 20 days.
Mr. Munda, I must tell you that in a 482 proceeding, I will not go into 161 statement.
I completely bow down on that. Only thing that in a very glaring manner, I want to show you, lordship, that I filed an FIR against them. The FIR was lodged against them. After 20 days, this is a cross FIR by them. And who are these witnesses? These witnesses are the persons who are accused in my FIR.
Wait, what happened to your FIR?
FIR charge sheet has been filed, my lord. Charge sheet has been filed.
What is your FIR number?
My FIR is at page 20.
Page 20.
20.
Page 20.
And 21, your lordship may see who are the accused persons.
Okay, 1 minute. 20, 20. 20 is your FIR. Huh? This is
Yes, ma'am.
FIR dated 63 of
This is 21st February 2022, ma'am.
21st February. Ah, yes, 21st February 2002.
Huh.
22.
22.
And
What
mine is of
the
April.
FIR against them?
Against this petitioner, FIR number date code.
Huh? What is
3rd April,
this is
ma'am.
your FIR? This is FIR you lost against
I
them.
lost. Yes. And this one is a
Acha.
counterblast, ma'am.
Ravindra,
Because I am
Ravindra
working
Das.
in a government
And which is the
organization.
FIR against you?
Yes, yes.
Which
yes.
page?
That is
9,
page
ma'am.
number
Page 9.
9. Page
What,
number 9.
Mr. Mahajan, what Maharaj, what happened this FIR?
3/4/2022.
This FIR at page 20?
Page 9.
No, page 9, so you have filed charge sheet.
No. Page 9 FIR. This present FIR against this petitioner.
I am not. 1 minute.
No.
I think
Ticket.
give some credit that I should understand.
Ticket.
Madam.
Yes.
There are two FIRs.
Yes.
The FIR at page 20,
Yes.
which came in the later point in time,
Right.
is filed by
This
this
petition-
accused against the opposite party number 2, Ravindra. What is his
Yes.
name?
Yes.
Ravindra.
Yes.
something.
Yes. Ravindra Das.
And Ravindra.
Yes.
He is Manoj Kumar.
He is Manoj.
He is Manoj Kumar.
My-
And now Ravindra has filed against Manoj Kumar.
My lord.
And where he is aggrieved.
My lord.
What now? My question is, what happened to the FIR lodged by Ravindra?
Ravindra.
Yes.
Yes. That no document has been. I think well, that charge sheet is perhaps the in connection with that. Yes, I am saying.
Right.
134. 1 minute. Yes. But that is charge sheet has been filed.
Both the
Yes.
cases. Both the cases.
Both the cases.
Therefore, see, there are the petitioner has filed the present petition seeking quashing of the proceeding arising out of FIR number
134 of 2022.
134 of
22. Yes.
in PS Bhavani Patna Sadar.
Yes, sir.
Bhavani Patna Sadar. Under section 294 and 506 IPC at the instance of registered at the instance of opposite party number 2.
Yes.
Opposite party number 2.
Yes.
Mr. Moon, assisted by Mr. Sahu, contended that on the petitioners have also registered an FIR against the opposite party number 2.
Yes.
Being FIR number 63 up to 2022 in PS Sadar under section 341/323/427/34.
Nice.
Next problem. The FIR in question, the FIR in subject is a counterblast of the FIR laws against the opposite party number 2 by the petitioner. Mr. Moon has submitted that prima facie no case is made out. No case is made out against his client by the very reading of the allegation against him in the FIR as well as charge sheet. Mr. Maharaj, appearing for the state, submits that this is not the stage where the court should give indulgence to these accused persons because in both the cases charge sheet has already been laid down. Next problem. Taking into consideration the fact that the allegations are minor in nature, it would be appropriate to issue notice to the opposite party.
Yes, yes.
Get to levels. High levelized.
Facts and submission made in the bar, that the Mr. Sahu submits that his client would be submitting to the jurisdiction of the court by on or before 15th of February, and avail appropriate remedy under law. Next, taking into consideration the above facts and submission at the bar, the order dated 7/4/2022 passed by ASA,
Additional session judge.
Titlagarh.
Yes.
ASA Titlagarh in sessions case number 10 of 2017 is set aside, subject to the petitioner paying cost of rupees 500. Okay. Deposited this also. Is the same?
Different offense.
Offense छोड़ दो, बताओ ना when you got bail. When you have got bail.
Bail ନାହିଁ ଏଟା ସାକ୍ଷୀ ଚାଲିଥିଲା କଣ ଏଟା ଡକ୍ୟୁମେଣ୍ଟ ଅଛି
What happened in this case, my lord?
No, you tell me, matter is going on.
Already enlarged bail.
Enlarged on bail.
He faced the trial. During the time of accused statement, because of his fracture in the leg, he could not appear before.
313 statement.
Mine.
What, sir?
All the accused persons are already released on, acquitted, my lord. The present.
Then you have to face, what is the, pay little more cost.
Date ଟା କୋଉଠି ଅଛି
The petitioner has challenged the order dated.
Case number 11 and 12.
Petitioner has challenged the order dated 10/9/2019, whereby the court of JMFC trial है क्या? JMC Santala have issued NBW against the petitioner. So, sir, the petitioners are facing a trial. A petitioner is facing trial for alleged offense under section
394 of IPC.
394 of IPC. Mr. Sahu, Learned Counsel of the petition submits that at the time of recording of the accused statement under 313, the petitioner could not appear before the court due to fracture in his leg. Therefore, fracture in leg. The trial court on the land trial court issue NBW against him for his failure to appear, for the petition having failed to appear. He undertakes, he submits on behalf of his client that his client would appear on
15th February.
Huh?
15th February.
Client would submit to the jurisdiction of the court below on or before 15th of February, 15th of February. And avail remedy under law. Next program. Taking into consideration the facts and submission at the bar, the order dated 10/9/2019 passed by JMFC Santala in GR case number 189 bracket capital A from 2014 is set aside, subject to the petition paying a cost of rupees. Here we give little more because 2019 313 gets stuck because of it. Other accusation faced and they got acquitted also. So then give 1,000.
He never approved this Hon'Ble Court for passing of the proceeding reliance.
Still, I would have asked you to face it. Obviously, you are 1,000. Huh? 1,000. Yes. Next.